action. We get, but I guess 10 days out or so, but. Yeah, and yeah, but it's be 2 weeks, I guess. I give them enough time to.
Yeah, we just got to have time to serve that. Get that motion done and get it filed with the court and serve it.
If I do, say February 3rd work, that gives us a couple weeks out. I can go out further. It's up to you, Sarkat.
Yeah, Judge, I would actually go out. I would actually go out further. I don't know if you could do the maybe the 10th of February.
Yeah. Yep. How about February 10th?
All right. So February 10th of 2026, and still at 8:30 by Zoom. Is that right?
That's it.
All right. And then, Judge, does the court wish the show cause subpoena served by mail or by personal service? I was just looking.
If this one here, if he's not going to here, yeah, I guess it's he. Mr. Frank doesn't show up, I'd be willing to issue bench warrant at that time. So if you want to do, if you can get personal service, it'd be better.
Right. All right. Let me see what I got. Okay. All right. Let me see what we've got here. All right. So thanks a lot.
Okay. That's it.
Thanks.
Do you have other ones? Was that it for you?
No, that was actually it. Yeah, that was it.
All right. Thanks.
Yeah, have a good. Thanks.
Nice
Happy New Year.
Yeah.
Thanks.
Bye. And how about Oliphant Financial versus Kimberly Birchmeyer?
Good morning, Your Honor. Attorney Elizabeth Ellison, P82098 for the plaintiff.
You there? And how about Kimberly Birchmeyer? Kimberly Birchmeyer, anybody? Nobody responded. Looks like I got nobody in our meeting. Let's see. This is actually an adjourned date. Looks like defendant did not appear the last time.
Yeah, it looks like we were here December the 2nd, Your Honor, in regards to a creditor's exam. She was personally served that. So this was the order to show cause for her not appearing then.
Okay. Fine, defendant failed to appear today. Do you want a bench warrant then?
Yes, please, Your Honor.
Okay. Issue a bench warrant. And it failed to appear.
Your Honor, as to
Yes.
bond,
Yeah, I was just gonna ask you what you tell me first which
the outstanding amount is $15,291.31. That's the outstanding amount on the debt.
Yeah, obviously you get back full amount. How about we do a 5,000 cash?
Okay, thank you, Your Honor.
Sure. We'll do that on that one. And Sullivan, do you have other ones too?
Nothing further. Thank you so much, Your Honor. We'll get that
All right.
submitted.
All right, thanks.
Thank you.
Yep, bye. How about portfolio recovery versus Sean Urban? Anybody? I think I got somebody coming in. Portfolio recovery versus Sean Urban.
Morning, Your Honor.
Morning,
Attorney
Mr. Johnson.
Yeah, good morning.
Let's see. Do I have a Sean Urban? Anybody? Looks like I got nobody in our Zoom meeting. This is set for summary disposition motion today. Looks like files in order. Mr. Johnson, do you want to proceed with the motion?
I don't know if you want to give him more time. I know it took me a little while longer to get into court today. I don't know. It's up to you.
You know what? When you mean more time, you want me to just pass on it, or you want me just to give it a week?
Well, let's go with it. It's okay. He's not here. It's 8:45, I guess. You know,
If somebody does show up, what I usually do if they're on Zoom by now, that I'll but I don't see anybody on here. So let's just proceed if you want to do that.
All right. Well, let's do it.
Okay. It's all up to you. You can proceed for me.
Hey, Your Honor, thank you. This is plaintiff's motion for summary disposition. This relates back to a purchased credit card debt. Balance suit for $3,503.30. Mr. Urban has not responded to the motion. I don't believe so. I didn't get a copy. He's not in court today. Just based on the court rules, I think we're entitled to a judgment.
Okay, and the one I did have an answer file, but no response to the motion. And I could get a chance to review the pleadings with the attached documents, significant number of billing statements going to the defendant, Sean Urban. See if I got the same. Yep, 300 Terrace Drive, apartment 78, and actually his answer to the complaint has that same address as well. Looks like the pleadings are in order. The attached documents for support for motion for summary disposition I've reviewed. Find there's no genuine issue of material fact. Grant motion for summary disposition pursuant to MCR 2.116. What was this brought under? Was it
I
a
think C10.
Yeah, I was, there it is. I do see C9 for sure. Yep, both C9 and C10.
Okay.
Grant motion for summary disposition. And Mr. Johnson, it looks like I got an order granting your motion attached. I'll sign that order for you.
Perfecto. All right.
Looks like you're all set.
All right. On to the next one.
Great. Hopefully it goes
All right.
just as easy. All right. Thanks.
All right. Have a good day, Your Honor. Thank you.
too. Yep. Bye now. Door Properties versus Dan Dingman.
Ready, Your Honor. Peter Dorr on behalf of plaintiff.
All right, let's see. Do I have Dan Dingman? Mr. Dingman, looks like you're there. If you could unmute for me.
Oh, there we go.
There you go. This is a schedule for motion for summary disposition today. Mr. Dorr, have the two of you talked? Would it help at all?
I don't mind talking to Mr. Dingman. I never got a response to my motion, so I don't know what
Okay.
his response is. I never heard anything. I also
Yeah.
never got a copy of the answer mailed to me. I had to fish it out from the court.
Okay.
So
Sir,
was
yeah.
there a response to the motion filed?
Just look at you, Mr. Dingman. Did you file a motion, response to that motion today? Summary disposition motion? I'm looking through the file. I don't see one.
I believe it was faxed in, sir.
Faxed in the response, or were you talking about your answer there?
My answer, I guess, I'm new at this, sorry.
Okay, I've got like, it looks like it was a screenshot maybe. I've got something that says, Your Honor, this letter is written on behalf of Dan Dingman. Oh no, yeah, that was from you. Okay, so that is just, it's not really in proper form for anything, but it looks like you're asking on that document to dismiss the case, I guess.
Well, I think the one I'm looking at is December 8th, 2025. It looks like a screenshot of an unsigned document.
That's what that's what I
Okay.
got.
So I
it's the
never
same
got
thing.
anything after that, and
Okay.
my motion is addressed to this unsigned document, which is non-responsive, doesn't state a valid defense, not signed.
Sure.
It's totally inappropriate as a defense, so it doesn't state a valid defense, which is the basis for my motion.
Okay. All right, why don't we do this, Mr. Dingman, as long as you're right here, if the two of you want to talk for just briefly, we can get something resolved outside of here. It might be beneficial to you. If we can't, we'll just proceed with the motion, okay?
My biggest
without-
thing, Your Honor, is that Peter Dorr acted on his own behalf to remove Rebecca Williams from the lease. There was no signed
You know what?
document.
I'll get to whatever you want to tell me after two of you talk. If you can get something resolved, that's fine. If not, we'll just proceed with the motion, okay? But I'll put you back in a private room with him first. Hopefully we can just get something resolved outside of me making a decision, okay?
Okay.
Okay, hold on just a minute. I'll put both of you back there. And Mr. Dorr, just for my sake, is this all you have today? Do we have
Yeah,
something
that's all
else?
I have.
Okay. All right, we'll get both of you back to a room here.
Thank you, Judge.
Okay, sure. And let's see, how about Champion Auto Sales versus Joshua Jones?
Good morning, Your Honor.
Miss Grim, got you there, and do we have Joshua Jones? Yeah, she's there. It looks like. Maybe you just need to mute for me.
I'm here, Your Honor.
Okay. Looks like this is. A motion to set aside payment order we had. See, the order says you would pay $100 bi-weekly starting July 15th, 2024. I'm sorry, it looks like I signed an order $100 monthly. Last one was starting July 1st, 2025. Let's go from that point on. Miss Jones, did you make payments? Have you been making payments $100 per month starting July 1st last year?
I was only able to make
Present before the court is Mr. Frey, represented by Mr. Perry, and we have Mr. View from the prosecutor's office. We are here today for a pretrial, but it's my understanding Mr. Frey is going to be entering a plea of guilty, and we're going to set this for sentencing. Is that accurately stated?
It is, Judge. Yes, Your Honor.
Mr. Frey, how old are you?
58.
How far did you go in school?
Graduation. I graduated.
Are you able to read and write?
From high school.
Are you able to read and write English?
Yes, sir.
Are you under the influence of drugs or alcohol?
No.
Are you taking any medications?
Blood pressure medicine and stuff for my stomach.
Are you taking anything that would interfere with your ability to understand what we're doing here today?
No, sir.
Are you a United States citizen?
Yes, I am.
If you enter a plea of guilty to this charge, I'm not going to sentence you today because I don't know enough about you and I don't know enough about this case yet. What we're going to do is conduct a level 2 pre-sentence investigation. We're going to come back here in about 8 weeks for sentencing. This seems like the kind of case that I'm going to put you into my community control program. Other than that, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No, sir.
I have a document entitled Change of Plea and Entry. On the second page is a signature above the line defendant. Is that your signature?
Yes, sir.
Did you review this with Mr. Perry before you signed it?
Yes, sir.
Are you satisfied with the representation that you have received in the case?
Absolutely, sir.
You're going to enter a plea of guilty to 1 count of aggravated possession of drugs, 3rd-degree felony, punishable by up to 36 months in prison and a $10,000 fine. It also carries with it, if I were to send you to prison, an optional period of post-release control of up to 2 years. We also have the physical control, which is a first-degree misdemeanor punishable by up to 180 days in jail. Before we go any further, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. If they can, you have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to these charges, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the sentence. Is that what you want to do?
Yes, sir.
Mr. View?
Your Honor, if the case were to proceed to trial, the state would produce evidence beyond a reasonable doubt that on June the 3rd of 2025 in the city of Monroe, Warren County, state of Ohio, that officers responded to a gas station where the defendant was in the driver's seat, slumped in his vehicle, unconscious. Keys were in the ignition when officers were able to rouse him. He had slurred speech. They observed pill bottles, track marks on his arms. He consented to a search of his vehicle. Located within was 7.7 grams of methamphetamine, as well as tourniquet kit. The defendant performed poorly on field sobriety tests and was found to be impaired in the opinion of the officer.
Anything on those facts, Mr. Perry?
No.
Mr. Frey, did you hear those facts?
Yes, sir.
Do you admit that they are true?
Yes, sir.
Do you understand the rights you're giving up by entering a plea of guilty?
Yes, sir.
Is this what you want to do?
Yes, sir.
What's your plea?
Guilty.
Based upon the plea of guilty, I'm going to find you guilty. I think you've made a knowing, voluntary, and intelligent choice here today, only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. I'm not going to go into the matter of the sentence today. Instead, you're going to go back down to pretrial services, and we're going to fill out the paperwork for the PSI. We're going to pass our drug test today, Mr. Frey?
Yes, sir.
All right, well, after we get done with court, you may want to have a heart-to-heart with Mr. Perry about whether or not, in fact, that is true. Because if it isn't true, you may want to have him stick around, because if you don't pass your drug test, you're not going home today.
I understand, sir.
All right,
Thank you, Judge.
that's all. All right, we're still waiting on inmates, right?
Morning, Your Honor. For the record, my whole Tepe.
All right, Mr. Burke, we're going to call your case in just a second. So if you could just remain on the line, please.
Absolutely, Your Honor. No problem. Thank you. Good morning.
Thank you. Good morning. And then let's see here. Mr. Gallagher, 1 second. Mr. Gallagher, are you able to hear me okay?
Yes, Your Honor.
Okay. So let's go on the record in People versus Anthony Gallagher. This is file number 256872. The record should reflect Mr. Gallagher is present today by video from Otsego County Jail. If I could have counsel put your appearance.
Morning, Your Honor. For the record, my whole Tepe.
Thank you, Your Honor. Richard Trush, on behalf of Mr. Gallagher.
Mr. Trush, can you tell me the status of this file here today?
Yes, Your Honor. We have a agreement that we intend to enter into today to resolve the matter. Mr. Gallagher would plan to count two, and the enhancements would be dismissed.
Mr. Roll, is that a correct statement of the plea offer?
It is, Judge.
All right, Mr. Gallagher, were you able to hear that?
Yes, Your Honor.
Is that the plea agreement that you've discussed with your attorney?
Yes, Your Honor.
And did you want to go forward with that plea agreement today?
Yes.
You raise your right hand, please. You solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You can lower your hand. Mr. Gallagher, are you currently on any kind of probation or parole?
No, sir.
You understand that by pleading guilty to count 1, which is possession of methamphetamine, that the maximum possible penalty that you could face would be up to 10 years and or a $15,000 fine. Do you understand that?
Yes, Your Honor.
With that in mind, what is your plea to that charge today?
Guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at a trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during the trial and to not have that silence used against you. and the right to testify yourself at a trial if you wanted. Do you understand all those rights?
Yes, sir.
And do you understand that you're giving up and waiving all of those rights by pleading guilty today?
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you can only do that by leave. And that means that you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. Do you understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we've said here on the record today?
No, they have not.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty to this charge because you are actually guilty?
Yes, Your Honor.
The information I have indicates that this happened about a year ago on January 17th of 2025. Is that the correct time frame?
Yes, Your Honor.
At that time, were you present here in Otsego County?
Yes.
While you were here in Otsego County, did you have possession of some methamphetamine?
Yes.
Did you know that that's what that substance was?
Yes.
Did you have any legal right to have any amount of it at that time?
No, I did not.
Mr. Roller, are the people satisfied with the factual basis?
Yes, Judge.
Mr. Trush?
Defense is satisfied.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
Aware of none, Your Honor.
And are you both satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor. Defense is satisfied.
Thank you. Mr. Gallagher, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. Between now and then, you'll be meeting with someone from the probation department for a pre-sentence report. And you'll have an opportunity to review that with your attorney prior to the sentencing hearing. Mr. Trush, is there anything else we need to address on this file today?
Not on this file.
Mr. Rolla?
Sure, thank you.
Mr. Gallagher, do you have any questions about how we're going to proceed with your case?
No, I don't, Your Honor.
Okay, thank you. That's all for this hearing today, and the court is going to disconnect.
Thank you. Have
All right, Mr. Burke, we're still waiting for Mr. Dion's counsel. We have a bit of a snowstorm up here overnight and into the morning, so she's running late, so we'll get started with your case as soon as we can.
No problem, Your Honor. Sounds good. Thank you. Appreciate that.
Mr. Trush, did you have Mr. Drysdale?
I do. Is he logged into Zoom? The court had previously approved his Zoom appearance.
You see that, but I don't see him, so we'll just pass that for the moment. Sir, are you Alan Millsap?
Yes, can you hear me?
I can, thank you. All right, we're gonna go on the record in People versus Millsap, and this is file number 256912. The record should reflect Mr. Millsap is present today by video from Department of Corrections. Mr. Millsap, the court set this for a hearing today because we have a jury trial scheduled in your case for March. And we received some information that your attorney, Mr. Mataloni, passed away in December. Is that your understanding as well?
That's correct.
So I scheduled this hearing because I wanted to see where you were at in terms of counsel, if you were planning on hiring your own counsel, if you wanted to request court-appointed counsel. Can you tell me where things are at from that standpoint?
Yeah, I have two new lawyers, Marcus Baldori and Robert Baldori.
Okay. And do you know, are they gonna file appearances in the case? Because we haven't gotten that yet.
Yes.
All right, and is it gonna be your intention to have them proceed with that trial as scheduled in March? Or do you know if they're gonna be wanting more time since they're coming onto the case at this point?
It's my understanding that most likely they're gonna want that to change so they have time to prepare.
Okay. All right, thank you. Mr. Rolla, was there anything that you wanted to add for the record?
Judge, we haven't, I was just indicating, we haven't received any appearances yet either, but should they file them, obviously with them coming in, people aren't gonna have.
Mr. White, do you understand the rights you're giving up by admitting to this violation?
Yes, Your Honor.
Is this what you want to do?
Yes, Your Honor.
Do you admit or do you deny that you violated probation?
I admit, Your Honor.
Based upon your admission, I find you have violated the terms of your supervision. Mr. View, anything from the state?
Your Honor, at the time this case was resolved in 2023, the court gave Mr. White, I think, a generous opportunity to engage in treatment and supervision in order to avoid what, given the circumstances of this offense against young children. And he has not followed through with what the court's opportunity. He has not taken advantage of those things. He has failed to avail himself of treatment and supervision. He's picked up new charges for failing to register during that time. And I think that he is just not a good candidate to continue in community control. I think absconding in general indicates an unwillingness of the defendant to engage in treatment, and the alternative, and really I think the appropriate sentence at the time of the sentencing, the state recommended a 60-month prison sentence. I think that is appropriate. I think that his probation should be revoked and that sentence should be imposed.
Mr. Williford, anything from probation?
Nothing further, Your Honor.
What's our jail days as of today?
297, Your Honor.
Mr. Nelson?
Your Honor, the defendant did do the CCC program, and I believe that he completed that. And then after that, he was released and sent to Kentucky on interstate compact. When he moved to Kentucky, he moved in with his mother, and then he became homeless after they were evicted from their house because he was not allowed to live there. After that, he moved in with his grandmother, and the same thing happened there. They were living in a car in a parking lot. He indicated that he went to register, and he was told that he was not allowed to register at homeless. And it was at that point that he stopped participating and he stopped doing what he was supposed to. And he didn't pick up any other offenses other than his failure to register. On the failure to register, he was given here in I believe, I don't remember what county, but he spent 7 months of that time and was released on New Year's Eve. He was told that there was a holder on him from Warren County. They did not hold him, and he was released, and he came to Warren County and he turned himself in the next day. I believe that after speaking to him, he understands that he can't live in Kentucky because it's not set up for him to actually succeed on probation there. He seems to be motivated to get drug and alcohol treatment, and I believe that if you placed him back on probation, he would be motivated to do so. And if the court is not inclined to place him on probation, I can't say that I have a mastery of the facts with regard to what he pled out to 4 years ago, but I do know that he pled out to a thing that he did when he was 16 years old. And it's interesting to give adult time to something that's happened when he was 16, but we understand the system that we're in, and we understand where we are right now. And he understands the consequences of what he pled out to. We would ask that if the court has it within its power to place him into an inpatient setting to where he could get some drug and alcohol treatment, and perhaps some psychological treatment that would help him, because he has some clear views and ideas on where he wants to go with his life. And I think that he's motivated to do so. But that's all from me.
Mr. White, anything you want to tell me?
Yes, sir. I would like to take full responsibility that I have made some very bad decisions, and I wish to make things right and to go back out into the community after some needed treatment, drug and alcohol, and mental health treatment. I'm very motivated to do the right thing, and I know what career path I want now. Whereas before in my life, I had no idea, and I was just kind of going day by day. I know what I want to do with my life, and I just want to get better, become a better person, and not waste the potential that I have as a young man. Thank you, Your Honor.
Reality is, Mr. White, it's just impossible for us to supervise the people that don't show up. And I mean, I get that, you know, we had some issues with homelessness and all of that, being evicted and so forth. But you were gone for a long time. And this was a serious offense. I know it happened when you were very young, but it doesn't make sense for me to keep trying the same thing over and over again and expect a different sort of result. I am going to revoke your community control, order that you be sentenced to prison. I'm going to order that you be sentenced to 18 months in prison. That's on count 2, 3, and 4. I'm also going to order that it'll be a concurrent 18-month sentence for 2, 3, and 4. I'm going to sentence you to 18 months in prison on 9, 11, and 12. And I'm going to order those 2 concurrent sentences be served consecutive to one another. So you have a 36-month prison sentence, and I'm going to give you credit for the 297 days that you have already served. This includes a mandatory period of post-release control of 5 years. That means the adult parole authority is going to supervise you. If you violate the terms of that supervision, you can be returned to prison for up to 1/2 of my original sentence. Or if you violate by committing a new felony, then you can be returned to prison for up to 1 year, or the amount of time you have left on post-release control. It's automatically whichever of those is the longer period, and it's automatically consecutive to the sentence that you would receive for the new felony. My hope is, Mr. White, when you get out of prison, register, put all this behind you. Anything else we need to do? Anything I forgot?
No, Your Honor.
All right, finally, you do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer to obtain a transcript or to pay the costs, they'll all be provided to you at no charge. Good luck to you, Mr. White.
Thank you.
Next, Christopher Griffin, case numbers 25 CR 42381 and 25 CR 42803. Present before the court is Mr. Griffin. We have Mr. View, right, from the
Yes, sir.
prosecutor's office, and Officer Twark from probation. We are here today for a final violation hearing. What's our plan, Officer Twark?
Your Honor, after speaking with Butler County and also speaking with the court, the indication is that we are going to move forward with an outpatient level of care to continue with the program from CCC, as well as give Mr. Griffin the opportunity to address the medical and health concerns he addressed in the preliminary violation, including a monitor with curfew, which is based off of the original court's orders. And Mr. Griffin will have reported to Butler County to address the circumstances of his supervision there.
So, Mr. Griffin, we didn't really address this back at the last hearing because we didn't really know where we were headed. If you admit to this probation violation, I'm going to follow Officer Twark's recommendations. I'm going to release you from jail on electronically monitored supervision in order that you do outpatient treatment. Do you understand that?
Yes, sir.
You still have the right to be represented by a lawyer if you want. If you can't afford one, I'll appoint a lawyer for you. Do you want to be represented by a lawyer?
No.
Do you admit or do you deny that you violated probation?
Guilty.
I'm sorry?
Guilty.
All right. Based upon your...
If I admit upon it, I'll be released, said if I admit. Well, I still I can't hardly hear you.
All right. Well, what we're going to do, if you admit to this violation, is I'm going to release you from jail, order that you be placed on electronically monitored supervision with a curfew. We're going to get you into outpatient treatment, and you're going to report to Butler County because your probation is not over in Butler County.
Okay, I'm in.
Okay. Is this what you want to do?
Yes, sir.
All right. Based upon your admission, I find you have violated the terms of your supervision. I'm going to continue you on probation. I'm going to order that you enter into and successfully complete outpatient treatment, and I'm going to place you on electronically monitored supervision with a curfew for a period of 60 days. You do have to report to Butler County and make sure that you get squared away with them as well.
Okay.
Anything else we need to do? Anything I forgot?
No, sir.
What's our jail days as of today, Officer Twark?
256.
All right. Good luck to you, Mr. Griffin.
Yes, sir.
Next is the case of the state of Ohio versus Anderson, number 25 CR 43089. Present before the court is Mr. Stutz, right?
Yes, sir.
We have Mr. Harris in the prosecutor's office and Officer Henry from probation. We're here today, Mr. Stutz, because I've received a report that alleges that you have violated the terms of your community control in that you demonstrated an unwillingness to be supervised and you were not able to provide an acceptable residence for electronic monitoring. Officer Henry, tell me what's been going on in this case since we were here last.
Yes, Your Honor. On the same date that this case had proceeded with sentencing, Officer Ballin from the Community Corrections Department had reached out to Mr. Stutz about getting him started on GPS supervision. It is my knowledge that when it was explained to him that we would need to have verification provided for the address that he wanted to stay at, that was not able to be provided. Mr. Stutz had made a statement to the correctional staff that he wanted to speak with the mental health team, that if he was not able to speak with them, they would have to care flight him out of the jail as perceived to be threatening suicide. Correctional staff ended up searching his cell and found a tied noose to his top bunk that was hidden underneath the sheets. And according to Sergeant Laird, Mr. Stutz was placed on suicide watch, to where he was immediately started smacking his head on the concrete walls, and he reported that they had to remove him from the cell and replace him in a restraint chair due to this self-harm. After speaking with the mental health team, speaking with Mr. Stutz, it is my recommendation that a further assessment needs to be made to take a look at an alternative placement for Mr. Stutz, where his mental health can also be addressed, but also any housing issues can be addressed as well.
So, Mr. Stutz, it seems like we're trying to get a plan together. We had a plan that didn't really address all of these mental health needs. I don't know that I was as aware of those as maybe I should have been. The plan is to set this for another violation hearing, maybe at the end of the week, and hopefully have a plan in place by then. What do you want to tell me about all of this?
My girlfriend is staying with family, and she can't provide a lease agreement and a bill, but I am allowed to go there. So that's where the misunderstanding came into place. I was hoping I could go to sober living. I was approved through mindful healing before, but I thought I was getting out on probation, so I denied it when they came back and asked me for who they needed to send the letter to of acceptance. I had talked to Erica, so I'm hoping that I can go to mindful healing. Again, it was the one out in Middletown. There I can address my mental health. She said before that she could take me to my appointments, doctor's appointments and such. I felt like on last Tuesday, that I got my hopes up to get released and everything just crumbled. And I'm trying to get back out to the community and be with my wife or girlfriend. And I really hope that the court can see that I had one episode and I'm taking my medicine. I've been on my medicine since I've been in the jail. I'm really trying to get back on my other medicine that the jail doesn't allow, which is my Seroquel, which helps with my bipolar and my schizophrenia.
All right. Well, here's what we're going to do, Mr. Stutz. I'm going to set this for, we'll know something by Thursday, right, Officer Henry?
I would imagine so. I have the referral. I'll have it set by today. My optimistic hopes would be that either the coach or mindful healing would be able to get him assessed by tomorrow morning or the next day.
Can I say something?
Sure.
The coach won't accept me because I have seizures. Mindful healing was the only one that was willing to accept me.
Generally speaking, the coach, if they won't accept, they will help with referring to other treatment agencies as well.
Yeah, I wasn't trying to interrupt you or get rude.
Oh, that's all right. Let's go ahead and set this on Thursday. Let's put it at 10:45, and hopefully Mr. Stutz will have a plan in place by then. Mindful healing seems like a decent alternative to this. We need to figure out a way to get you out of the jail, but I do understand what you're saying about, oh, this is just one episode, but a noose in the cell is a very terrifying prospect.
Yes, sir.
Because the thought is the next time there's a noose in your cell, there might be a person in it. So we need to make sure that we are exploring a higher level of care. So let's come back on Thursday. Hopefully we'll have a plan in place. My goal is to get you into mindful healing, someplace like that, out on a monitor, and reboot this case back in the community.
Is Nova House an option?
We can reach out to them. It's the issue regarding like expediency might become an issue with Nova House. Because they usually have a wait period for getting new clients.
Usually it takes a little while to get some people into Nova, but I am an all the above right now. So let's find out the best option and we'll get them there.
Okay.
Okay. All right. I'll see you on Thursday.
Thank you, Your Honor.
Thank you. Yeah.
And you said does all the cases of, I'll call it under Rico McGuire versus Arbor One, or Arbor One versus Rico McGuire. Et al. Counsel, state your appearances, please.
Good morning, Your Honor. Deputy Gordon Lehman here on behalf of Arbor One and Arbor West.
Does all the cases of, all right. Under Rico McGuire versus. And good morning to both of you on this cold Michigan day. All right, I had received a copy of the Court of Appeals decision, which I think was an appeal taken, I'm presuming, of Judge Conkey's ruling.
Yes.
And they affirmed Judge Conkey's. While I was trying to digest that, I'm not sure what that means for these cases.
Agreed.
So, yeah, and that decision from Conkey it covered a lot of different things, but I think relevant to this case is that it covered that the tenants wouldn't have to pay rent going forward and that they could apply for the escrow to be released in the 14A court as well as the city of Ypsilanti. And since that was appealed, I think that was delayed, but now that appeal has been affirmed, that decision has been affirmed, I think, again.
Well, was it delayed?
My understanding was one of the reasons why the escrow is still in this court is because there was some dispute on that appeal decision.
I
don't think that that's true. As I understood Judge Conkey's decision, there was a process by which the tenant could request the escrow to be released. I don't know that, and that those funds for the respective tenants that had escrow could be released. I think we have had maybe 2 or 3 that have requested it. In fact, there's been 3. One requested the money back to pay their rent at their new apartment, and that was fine. They filled out, I think your office, Mr. Henry, filled out the paperwork for them. It went through, we processed out their escrow. They came and picked it up. There were 2 others, I think, if I'm recalling correctly, where there was a request made by the tenant to release the funds because they had a pending case. They had moved to the villas, so they had moved to 14B jurisdiction. And so they requested that the funds be released. I'm not sure specifically what the request was necessarily, but the way I took the request when they referenced the other case number at 14B is they were trying to satisfy the escrow requirement at 14B. So in those instances, we release the funds directly from 14A to the 14B escrow. And those checks were sent. So that's the long way of saying, I don't think it was anything having to do with the decision, because I'll be honest with you, I was not aware, because these cases are tangential to it in a lot of ways. I was not aware that it had been appealed. So doesn't surprise me, but I was just complying with what I saw as Judge Cookie's order. So
Understood.
So having said all that, it was nice for me to get to talk this morning. What do we want to do with these cases? Because we still have a number of, I'm not sure, I don't have an exact count, but we have a number of cases where there's money in escrow. Do you have the calendar now?
I don't have the calendar.
Okay. And given where that case is, other than something specific from the circuit court, I'm not moving on that escrow. Which, lucky for me, means I cannot close these cases. Any suggestions, Counsel?
Well, Your Honor, I think you have entertained some of the applications from the tenants individually for the escrow, so we could continue on that basis. But I think we'll also be bringing up this issue to the circuit court to see if we can get a direct order that would address these cases.
That's fine with me. I thought that the order from Judge Cookie, and I have to go back and look, which basically indicated to the tenants that they could do things with the Ipsy City escrow as well as 14A escrow. I thought that specifically addressed, in essence, these cases. That was my feeling. It's just that if the tenants or no one comes forth, I can't act on my own to do something because I don't know where these tenants are necessarily.
I'm not really, Your Honor, if I may, I'm not really sure what Mr. Henry is referencing into regard to an additional order from the court addressing these cases. I think, anything pertaining to these cases is in some way already addressed via the current orders. We've got rent obligations or lack thereof addressed. We've got options for the tenants to, relocate, so I'm not really sure what additionally would need to be done via the circuit court to address these cases. Quite frankly, we've only got, I believe at this point, maybe 4 people who are on this docket that are still even at Arbor One. So it's, we're getting to the point where there's nobody even still in their units. My numbers, we've got 4 who are still in their units. Everybody else is gone, been relocated. So, the impact on actual residents at Arbor One still before this court is very minimal.
Thank you. You actually addressed what was going to be my next question, is how many of the people that I have here are still at one, or, and I guess there's a second part to my question, or who are intending to return to Arbor.
At this point, I know that essentially every tenant who's not at Arbor One West is going to be required to move out by the end of this month. So I know that there's at least a few people in the Arbor One West buildings that are in this courtroom. I think Mr. McGuire is one of them.
I see.
And so those ones are kind of a separate case where they haven't been ordered to be relocated.
They haven't been?
They have not been yet.
And I guess, Your Honor, it might make sense to give you a little background on Judge Kunkie's most recent order. So at the end of December, I believe the 29th it's the date, she entered an order. The parties essentially agreed that several of these buildings should be vacated. And so she entered an order where Arbor One is to offer two options to the tenants in 9 buildings. So these are all the buildings except for Arbor West, and then the 2 buildings that have TCOCs right now. So there are 2 buildings with TCOCs, 720, 721. There are tenants in there. Tenants are being offered relocations to those 2 buildings. But all of the other 9 buildings are ordered to be vacated. And so tenants were either to elect the option of being relocated to 720 or 721 and receive a cash incentive of $1,000 in assistance with moving to those buildings, or they could take a cash for keys option where they would be provided $3,500 as soon as they signed an agreement. Excuse me. And they would be ordered to be relocated or vacate their building by January 31st. Excuse me. Sorry, Your Honor. And so that's the current disposition of 9 of the buildings. So those 9 buildings those tenants have to be out by the 31st, or they've been advised that we're able to evict them. And Judge Kunke has agreed to have jurisdiction over those evictions, and we'll hear those if those folks don't leave. This order does not apply to Arbor West. So there are folks still in Arbor West. And so they don't have this same obligation under this order when it comes to making an election. So, but everybody at the property as of to date have been offered the option to relocate to a TCOC unit. Some have accepted, some have declined. So that's the current status of the most recent order from Judge Kunke. So I think that speaks to a little bit of what Brother Counsel is mentioning.
Got it. Okay. So at some point, I guess, come the end of this month, something's going to be settled regarding this. The real question would be then I don't know the status of some of these individual tenants that have escrow. Certainly I could, if we located them, I could just release the escrow back to them and close my cases out. However, I don't know if that type of decision would be consistent with what Judge Kunke sees in this case.
My understanding is that it would be from the order that escrow, I think, would all have been paid after September 17th, 2024. So I think that would qualify as the money that should be released back to them. And I do understand that the issue is locating some of these tenants. We have information on, I think, a decent amount of them through the union, the tenants union. And we'd be happy to.
But does the order say to release it back to them?
It says that to the extent rents are being held in escrow by the 1480 District Court and or the City of Ypsilanti, tenants may apply to those entities for the release of escrow funds pursuant to this order.
Correct. Okay. It may be a distinction without a difference, but that's a little bit different than saying just release it to them. I also don't know how many of these other tenants have cases potentially pending elsewhere, which they may believe, and it would be incorrect, but they may believe that they put money into escrow, but it resides here and not in the jurisdiction that they may have their case pending. So how fast can you, through the tenants union, maybe locate some of these individuals?
We can probably send out a blast email today. Hopefully we can get a response within the week on the location of most of these tenants.
Okay. there was at one point, there was and council can help me with this, that there was a form that was generated that would have to be signed off on by Beal and also the tenant that was presented to this court. I then fashioned an order and released escrow. Is that process still in effect or no?
I think that would be the move-out agreements that.
Yeah.
That's still technically in effect, though there's been some lagging behind on getting those paid out since about October.
Okay.
With regards to the 9 buildings that are subject to the most recent order, the current order gives a different offer. So if we're talking about move-out agreements for Arbor West, I think that's a different conversation than if we're talking about move-out agreements for the 9 buildings who have the new order for the cash for keys. It's a different process. And so I think those are different conversations depending on where these tenants may have been located.
Okay.
It's
No, that makes absolute perfect sense. I guess the one thing I would need to know is, to the extent any of the tenants are in those 9 buildings, would the offer that's being made, or what's being made to these tenants, in addition to or in lieu of what's in escrow? I mean,
I think the move-out agreement, it would basically be the rent back from September 17th, 2024 onwards. I think that could encompass the escrow. The new agreement is basically just a cash for keys offer, so that would be in addition, I think, to anything they had in escrow.
Respectfully, I would disagree.
Why did I see that? I saw that coming. Okay, I would then need clarification on that. Whether the amounts I have in escrow are in addition to, or because in one instance, the intent can be to make sure that the tenant has enough monies to move, which the escrow would then be there. The other intent would be that the landlord needs to pay this amount, and regardless of anything else, and do that. And I can see the argument kind of being made both ways, because had the court not ordered escrow, that those monies would have already been paid over to the landlord. And so the landlord would then be, in terms of even what the landlord was paying out, the landlord would have paid out a certain amount. But I would need some clarification as to how the escrows here interplay.
And I can tell you also, Your Honor, Judge Kunke is actively working on scheduling a settlement conference with the parties. And so, again, I know that we were in mediation prior to this, and I think the idea behind some of that is some of these issues that we're talking about here could be decided, and figured out via mediation. So it could be that in the next couple of weeks, when a scheduling conference is held, which seems to be the case given dates being floated, that some of these items could be resolved via mediation and settlement. So
okay, that I would love to see that happen. So why don't I do this? Why don't I adjourn these out? I'm going to give you a first week in March, because nothing ever seems to operate on the schedule I like to set. But let me see what day.
March 3rd.
3rd. Why don't I adjourn these out to March 3rd, 9 a.m. And if in the while I've adjourned it out, the court's intending adjourning it out is basically a placeholder and then sort of an update as to what's going on. But if the issues regarding these particular tenants in the escrow, if it's resolved prior to that point in time, certainly you can contact the court and I could set a earlier date if we need to.
Sounds good.
That sound reasonable to everyone?
Works for us, Your Honor. Thank you.
All right. So March 3rd, 2026, 9 a.m. Thank you, folks.
Thank you.
I didn't tell you to grab that. Why are you yelling at me? Huh? Go ahead. Thank you, Mr. Henry. Haverhill on Clark versus Jeffrey Thompson. Your name? All right. Where are we on this?
I believe that, I believe the third or fourth, hearing, I believe, except for a final settlement conference. In the last hearing, another attorney appeared. However, there were just some talks about documentation being exchanged with regards to this the situation with Mr. Thompson, which our client was supposed to review and potentially try to resolve the case. However, my client still takes the stand that they want to proceed on this eviction. We do want an opportunity to be able to subpoena some witnesses. We just didn't have the opportunity to do so, seeing as how the time that elapsed between the last hearing and today was not enough time for us to do so.
So you still want to proceed to trial?
We do, Your Honor. Unfortunately, absent adequate reassurances of.
How do you adequately reassure anything regarding mental health?
And Your Honor, that's one of the issues here. The problem is that this eviction is not meant to punish Mr. Thompson.
Oh, but it is.
Well, Your Honor, respectfully, at this point, it's just about protecting the other tenants, their concerns or their safety, and it's essentially a violation of their implied covenant of quiet enjoyment, and so it also subjects us to potential for liability with regards to breaches of contract with the remaining tenants. So we would like an opportunity to bring the witnesses in to testify. In the interim, we can still try to resolve the case. We're still trying to work with, we can still try to work with Mr. Thompson, but I'm at the mercy of my client here, unfortunately, Your Honor.
Why does this continue to drag out?
Say, go ahead.
Why does it continue to drag out? I'm not.
Well, hold on, Mr. Thompson, let me ask you this. Remember the last time we were here, you were going to try to get certain information over to, did that happen? Yes? Okay, you got to verbalize for me because we're recording. No, it's okay. It's okay. So that got out to them.
Yes.
All right. And so your question is why it drags out. The proceeding has to go through certain things, right? And so the times that we've been here, we've been the parties to an extent have been looking to resolve it, but that required some information from you to get to them so that they could consider it. Apparently that's gotten there. They've looked it over and considered it, and now they would like a trial on this. Okay. Now, Mr. Thompson, are you going to be able to handle a trial on your own, or are you going to?
I don't know.
Pardon?
I don't know. I have to talk to CMH.
Okay.
Sorry.
No, it's okay. It's all right. I asked the question not knowing what answer I would get, but that's fine. But I think what I'm gonna have to do is I'm gonna need to set this for a trial. All right. And at that trial, you're gonna be able to give your, basic formatting is each side's gonna be able to give me their opening statements. Plaintiff is gonna put on their witnesses to basically indicate to the court why you should be evicted. I'm sorry, say again?
I didn't hurt anybody.
Okay, Mr. Thompson, just listen to me, okay? And that may be indeed part of your defense. But you could have witnesses, you can call witnesses on your behalf. For example, one thing that we do know is there were periods in time where there was a change in medication. If you can bring people forth that know that information and want to testify. All right. Then after that happens, the people can put on their rebuttal witnesses if they want to. And then each side's going to give me basically their closing argument. They're going to argue why you should be evicted. You're going to be arguing why you shouldn't be. Okay. So that's just another step in the process that we have to go through.
Okay.
All right. You all right? Okay. I know you've been talking with, you have your CMH people, you've been talking with people at Legal Services too, or no? Alex that was here today. Did you talk with him at all today? No?
I said, I don't, but.
Pardon?
I said, hold on.
Okay. All right. Why don't you give Mr. Henry a call and just let him know that I'm setting a trial date on this.
Okay.
Okay. And see what assistance they can give you.
Okay.
All right.
Thank you.
All right. So you made it this far. Okay. So there may be one or two other proceedings or something that we have to go through. All right. But that's the process we have. You have any questions regarding that process at all at this point?
I trust you.
Pardon?
I trust you.
Well, thank you for saying that a lot. I don't get that a lot, but that's okay. All right.
Judge, I would like to just note for the record that I did speak with Alex.
Oh, Mr. Henry, you did?
I tried to get an update from him, asked him if they were going to be potentially still assisting him on an advice-only basis, if they still do that as kind of a friend of the court. And he indicated that he wouldn't be appearing, he wouldn't be speaking on behalf of the defendant, but I still think he should still reach out.
Yeah. It's going to likely be that they'll be assisting him, I guess, in the background or whatever is likely what's going to happen. Okay. So how much time are you going to need, counsel?
We just need enough time to subpoena the witnesses, the tenants.
Okay.
So, I mean, it usually takes, what, 4 to 6 weeks, I think.
You can't add 4 to 6 weeks. You hear that? Jeez, oh Pete. Where's my regular staff?
And then I will indicate to the court that we will still attempt in the interim to try to resolve this amicably. If there's something that we can do, we can still attempt to do that. I mean, parties are obviously have the ability to do that.
So it's going to have to be the end of February.
The last date in February is 17th. Yeah. Or there's March 3rd or March.
Set it, I think, March 10th, and you're gonna have to give me a gap on that because it's gonna take a bit.
Okay.
You know what I mean?
Yes.
All right. So I'm gonna set non-jury trial in this matter for March 10th, 2026, 9 a.m. Okay. All right. So that's when you have to come. Do you have any other questions Okay. All right. So we'll come there and then ultimately I'll hear everything and then ultimately I'll make my decision on it. Okay? Now, I know in the interim, and I'm just saying this, and I'm going to tell you the same thing I told you before. Between now and that date, absent something occurring, it seems like things are going well for you right now. Nothing's going to happen to you.
Yeah.
Okay? And nothing will happen to you without me saying it. So what I say that so that you're not worried each day that all of a sudden something is going to occur. Okay? Got that? Okay. Thank you, folks. Town Center Place versus Sigrid. Can you hear me?
Yeah.
Okay, fantastic. All right, I've called all three of these cases. And,
Good morning, Judge. Mark Glassberry for plaintiff.
all right, state your name.
Mike Melvin.
Okay, your name.
Secret Melvin.
Thank you. All right.
Judge, when we were last here in December, I think the stage was set to discuss a conditional dismissal.
Yes.
I do have, I would propose a standard scale form CD with an addendum.
Okay.
And I have an addendum that I'd like the court to look at, and I'm presenting that to Ms. Melvin and her son. Can you make it a little bigger so I can see it?
Okay, I see what you're saying. Is there a bigger, or do you want us to blow it up? Can you see it or no?
Well, I forced myself.
Okay.
The defendant agrees to do the following. Complain with pest control and properly just.
Why don't I do this? Let me pass this briefly, let you go out. You can use one of the conference rooms and read that to her and make sure she understands it. They're right outside the doors to the side. All right, quarter past these matters. Ready? Yeah, she's gonna have to take that with her. All right, thank you. Where's the other part? Oh, they're all in one like that. Fixing housing 401k plan versus Erica Ward and Aaron Ward.
I don't know about this. All right.
Who is
Good morning.
Good morning.
John, I'm not sure about that case. Good morning, Your Honor. Steve Otherby on behalf of Plaintiff Fixing Housing 401k.
Erica Ward.
Aaron Ward.
Thank you. You may be seated. Folks, you were trying to figure out your case.
I
question, I was planning on our arrest thing, do I have to stay in here? Or?
Oh, Mr. Hurt, no, we're adjourned out.
Okay.
And-
So that's why I was here, I was planning on our arrest.
Okay, are you still, let me just ask you this, what's your name?
I'm still living in our arrest. I'm planning on our arrest.
Okay, so you're still there. Okay, have you been dealing with the tenants union and?
I've been talking with them guys.
Okay, so what I would suggest you do, because Arbor West falls into a sort of a different category than the ones that have to be vacated. I think that's what they were telling me.
That's where Henry, I talked with him like about a week ago.
Okay, so I guess if you don't have to remain here. If you have any questions, then you need to direct it to them. Did you post any money, just out of curiosity, you post any money into our escrow account? You did not. Okay. All right. Very good. Okay. Thanks, guys. Okay, folks, where are we on this case?
Your Honor, we're here for our 7th hearing in this matter. If you recall.
And you might be to 10 by the time you guys get done, but go ahead.
But at the last hearing, we had our motion, it was a motion hearing.
Yes.
And you stopped it and it essentially became a settlement conference.
Yes.
Nothing came out of that. It didn't settle that day. How about that? After that hearing, the tenants sent 2 notices of repairs, which one of them matches one of the pending motions that's before you. Our response to that motion would apply to the second notice of repairs. And Your Honor, also, I learned on Friday afternoon, I received an email from Donna Tepe with the filed correction of defendant's response to plaintiff's motion for summary disposition that was filed on their behalf.
You received what?
I received an email from Donna Tepe with what appears to be, and it's a filing. It's called Correction of Defendant's Response to Plaintiff's Motion for Summary Disposition that was filed on their behalf.
I did not. That was on Friday you received it?
I received that on Friday afternoon. And this.
Oh, I got there.
I may be able to.
Hold on 1 second.
Your Honor, I also have the email from this, which it appears like she's still representing.
I don't.
Oh, there it is.
January 14th. They just threw it in the pot. All right. Okay. I did not get a judge's copy of it, but I'm just. So. Okay, go ahead. I scanned it, but it's basically her affidavit, it looks like.
Your Honor, it appears to be a supplemental corrected affidavit by Ms. Tepe. It's blamed on a computer glitch from the previous affidavit that she filed in response to landlord's MSD. I have many problems with the filing. At December 19th hearing, you ordered a moratorium on plaintiff's motion or party's motion practice. And it does not appear that they asked you for leave to file this corrected response to our MSD. Tope filed this on behalf of the wards, even though she was required to withdraw from this case, and she did withdraw from this case. Tope's filing in her email, which again, I have the email, which demanded a copy of landlord's MSD. So it appears that she's still acting as counsel on behalf of the tenants. And tenants are responsible for their filings. They can't plead ignorance to this. The filing and Tope's affidavit are dated January 8th. That's 2 days after our last hearing. The proof of service also states that it was filed with the court and served on landlord on January 8th. The court stamp shows that it was actually filed on January 14th. And again, I didn't receive a copy of this filing until Friday afternoon, right before MLK holiday. Your Honor, I can address the substance of this corrected affidavit. It appears that she's still making the same residential lease argument that, as you recall, Your Honor, you warned the tenants that if they continue to make this argument, that they could be subject to sanctions. They made the argument, and they continue making the argument.
Let's deal procedurally, I guess, before I get to the substance of it.
I can address the substance.
Well, yeah, I know you can, but I want to try to figure out why this is here.
Okay.
You want me to address that?
Yeah, please.
I had no idea as to procedurally. All I did when we left is said, your affidavit was like glitched, incorrect, you've got stuff. And so I didn't ask her to do anything. She's not representing us. She just said, hey, just so you know, I fixed my affidavit. And that's as a witness, not as a lawyer. So what she says in her affidavit as a witness, I didn't have anything to do with it, and I didn't even realize it would be an issue. I told her that her affidavit was not correct at all, and that is how she followed up. She is not representing us, Your Honor.
This doesn't make much sense to me as to why she did this. She's not here to answer.
I have the email, which it appears that she's still acting on your behalf in this case.
Hold on, I'm saying, can you show, were they CC'd on that, do you know? Or can you show them, and then I want to see the email. Where's this?
That's fun.
I don't think it's a refiling. I just think it's a refiling of the original one with the correct affidavit. So I don't know
Okay.
the specifics of the law, but to me, it just looks like a corrected, something that she had already filed. Actually, the correction to what we filed.
Mr. and Mrs. Ward, I guess it would be one thing if you had filed something saying, here's the corrected affidavit. And if you went to Ms. Tope and said, this is all wrong, here's the corrected affidavit, and you guys sign off and you file. That's one thing. This is a whole other thing along when you take it in the context of that email. I don't know why she's still communicating with counsel. It doesn't make any sense to me.
I did not ask her to do that at all, and I understand what you're saying. It would have made sense for her to correct her affidavit and hand it to us so that we could submit it. I have no idea why she did that.
So here's where we get into another thing. She filed this without your permission.
Yes. Believe me, I'm
Have you
staying as far away from
have,
as possible.
did you read the affidavit?
The initial one.
No, I understand the initial one. Did you read this doc?
No, actually, I didn't. I did not.
I did not.
Updated, I mean, because I didn't even realize that initially when we submitted it, that we submitted something that had pages mixed up.
Your Honor, they're still responsible for their filings.
Yeah, but I don't know if that's their filing.
She mentioned about the pages being mixed up. Their response to our MSD, they are still responsible for their filings. That's all.
No, I understand that, but I don't know how I hold them responsible for things that were filed without their knowledge, is what they're telling me. That's the difficulty I'm having, right? Is that procedurally, if Ms. Tope came along and filed this, but had gone to them and said, here, this is, I see what you're saying, so I need to correct this. Here's this, I'm going to file this. That might be one thing, but that's not what I'm hearing here. I'm hearing that this was filed. You guys didn't have any knowledge as to its contents.
Correct. I did know that she corrected it after the fact and submitted it after she did it. I had no idea any implications that would come of that.
You had
I hear
knowledge
now
that she did, that she did what?
That she fixed it after the fact, but she never told me that she was.
What does that mean? That you had knowledge that she fixed it after the fact?
She told me she did it after she sent it to them, but it was already done. She never asked me if she could do it.
So after, when was that?
At some point after they received it.
But they just got it.
We received it Friday afternoon. Even though it's dated on there January 8th.
Yeah, I would have to look. I don't know.
And then you have to look at what?
My email.
Look at your email. I want to know. Take 14 days for an order to post.
Actually, there's nothing in here, so she must have just told me that she would fix it. If this is any help in understanding my brain frazzle, I also have a case of strangles at the farm.
What?
If this helps you understand my brain frazzle, I also have a case of strangles at the farm.
Okay.
Your Honor, I would add in the context that Ms. Tope is still representing them in the circuit court action.
Yes.
My understanding was that we were here today to continue settlement talks and that the settlement that we presented on the 6th was rejected.
Right.
Okay.
We might be. And I may have called the parties back and said, look, where are we? I mean, if counsel kind of let me know where his client, but the problem I'm having and what is creating a bit of a difficulty here is that there are documents that are being filed in this action, not by you.
Nor with my permission. I don't know how I.
I don't know, 14. It's 14 exactly.
Yes.
Was there anything recently filed in the circuit court action counsel?
No, Your Honor. Yes, our witness list. Yes.
Right. Okay. But I mean, anything else by Ms. Tope that was?
I filed my witness list and then she filed her witness list hours after.
After. Got it.
I can find that date. But to my knowledge, Ms. Tope is still representing the wards in the circuit court action. And it seems like they were still having communication in this case.
Yeah, and the communication I don't necessarily have a problem with. What I have because I don't know that I could stop that anyway. But what I do have a problem with, so when things are filed before this court, presumably on your behalf, but without your knowledge, that just it. And then counsel has to spend time looking at it and trying to respond to something that you guys didn't file. And you don't even know what it is at this point.
Tonight? No, it is long time classes.
I don't think either one of them said they've seen it before today. Did you see it, ma'am?
We talked about it, that she was updating it, but neither one of us read it.
No. I get that there can be these conversations,
Yes.
right? I mean, and I don't have a problem that she was going to update whatever.
Right.
Have you seen what was filed in court on your behalf?
No.
Do you know where Miss Tope is right now? Because I'm going to tell you, I'm a bit vivid, just a bit.
Can you take that up with her?
Well, I intend to, but here's the problem. Yes, I don't think the parties, and I'll just say this on the record, I don't think the parties were all that far apart in terms of how this matter could be resolved. That's just this court's view. But I also have these motions before me that I need to rule on. But at each, until we come back here, regardless of what the parties thought may happen, might not, whatever, right? She then interjects herself, and quite frankly, interjects herself in a way that for an attorney to do it, for anybody to do it is a bit appalling. For an attorney to do it is tenfold that. Because in effect, let's look at it this way. If Ms. Toper represented you, she shouldn't be filing anything with the court that you have not reviewed or she has not gone through with you and you have not seen. But she's now filed something not as the attorney on your behalf, and you have no idea what it is.
I understand. I should have taken her affidavit and had Aaron submit it. That's a correction.
But I'm not going to tell you what you should do because I mean, I haven't looked closely at what she submitted vis-a-vis the other part, but you can't respond to her affidavit.
As a witness, I thought, because she was a witness to the
No, but the affidavit is submitted as part of a motion for summary disposition. So if we go forward with the motion for summary disposition, you don't know what that says. Right?
Right. I mean, I have a general idea, but no, specifically, no.
You don't know what it says.
Correct.
The only general idea you may have is what Ms. Tope in the moment told you she was going to do. But you don't know what it says, do you?
No, not specifically.
So if I have counsel respond to the substance of this affidavit, I just want to be clear. You can't respond to the substance of what's been filed.
Okay.
No, I mean, that was a question.
Oh, I cannot give you the specifics of the substance of what was filed, other than it was the affidavit, and I know in general, as a boarder, what happened with her horse and the injuries sustained due to the fencing. And the witness that she is to the collapsing buildings and the fallen trees and the heavy equipment.
But this is wasting the court's time, and it's wasting plaintiff's time.
I don't need to.
What?
I don't need to talk about it. I thought you were asking me.
Well, the problem is maybe I'm a bit unclear. counsel receives this on Friday. That requires him to do certain things, increasing the cost to his client. He comes here and then has to spend time in this courtroom making an argument regarding something that you don't know anything about, but are connected enough to the person that filed something on your behalf. That's a problem.
Your Honor, I would just also add, this has been a pattern. We've had hearings set and tenants file motions and send them to me 2 days before the hearing. This is a pattern.
No, I get it. I get that part of it. And most of that stuff we can sort through, but when that was happening,
I think we got the motion for summary judgment the day we were coming in here. No?
well, you may have gotten it, but I think somebody.
Yeah, I had to file it. It wasn't noticed for the same day.
I'm gonna let you go ahead and argue your motion. All right, go ahead.
Your Honor, would you like me to address the affidavit?
Yeah, I knew we were gonna get there. Yeah, I'm gonna let you do your motion. It's a fair question as to whether or not.
Your Honor,
Hang on a second. The court's gonna stand in brief recess.
all right.
Good morning. And do I have a? Good morning, sir. You are Asa Joseph Jones. In cause number 25, DCCR 0963, you're charged with aggravated assault, discharging a firearm recklessly. That's from June 12th of 2025, and that's a first-degree felony offense, which means if you go to trial and you're found guilty, the range of punishment would be a minimum 5 years up to 99 years or life in prison. Do you understand? And I have here on the tablet a plea bargain rejection that has your signature on it with Mr. Burbanks that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for 25 years in the institutional division of the Texas Department of Corrections. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to enter a plea of guilty. And do you understand all of that? And do you want to reject this offer and have your case set for trial? All right, I'll get that done. As far as you know, all the discovery, you have everything. Okay.
We're not waiting on anything, Judge.
And is there any reason to believe that this offer would change, Mr. Coleman?
Not at all.
I want to make sure you understand, Mr. Jones, that after today, this offer will be off the table. If you change your mind later and want to enter a plea of guilty, you could do that open to the court or to some other plea agreement. But after today, this one's off the table. You understand? Okay, we'll get it set for trial. Mr. Burbank will begin preparation. Thanks. And then you have Kevin Ross. Okay, I'll take care of it in just a second. Let's get Calvin Randall. I can take care of Calvin Randall for Mr. Eckhart. We're just going on 2.
Yes, ma'am.
Thank you. I'll need, can you do one for each? It's easier for them. I'm gonna mark out the second number. If you'll do 1530 on the second one, please. Mr. Smith.
You marked out 1530. I need to write 1530.
Correct. Yeah, 1530 is what that one needs to be. And we're going on multiple counts.
They can both be. To a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter plead guilty to these charges, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the ILC. Is that what you want to do?
Yes, sir.
Mr. Harris, what are the facts?
Your Honor, if this matter proceeded to trial, the state would show beyond a reasonable doubt, in addition to all allegations in the indictment, that on or about September 19th of 2025 in the city of Franklin, Warren County, Ohio, defendant Eddie Devin Gabriel Pena was intoxicated and found to have a firearm on his person. Further, Mr. Pena obstructed official business by pulling away, walking backwards, and refusing to comply with verbal commands. He had to be carried to the police cruiser. He pushed against the cruiser to stop officers from placing him inside. He also refused to give his personal information.
Anything on those facts, Mr. Chambers?
No, Your Honor.
Mr. Pena, did you hear those facts?
Yes, sir.
Do you admit they are true?
Yes, sir.
Do you understand the rights you're giving up by entering plea?
Yes, sir.
What's your plea?
Guilty.
I'm going to accept your plea of guilty. I think it's been made in a knowing, voluntary, and intelligent fashion only after you have been fully advised of your constitutional rights, which you waived and rejected here in open court. I am going to grant the motion for intervention in lieu of conviction and order that these proceedings be stayed for a period of 3 years. We're going to adopt a treatment plan for outpatient treatment. You're going to be under the general supervision of the probation department. Not on probation, but those are the folks that supervise my ILCs. They're going to be subject to random drug testing. We're going to forfeit and destroy the firearm that was involved in here. And sometime in the next 120 days, you're going to begin serving a 30-day jail sentence, but you have credit for the 5 days you've already done. You can do that with work release if you have employment, or you can do the litter pickup program. That means if you do litter pickup, you get an extra day of jail time credit for every time that you go out on litter, so you can shorten your sentence, or you can have work release, but you can't do both. Anything else? Anything I forgot?
Part of that plan was corrective thinking in order of the court as well.
Is that what we're doing?
I think that would be a good idea.
Okay, makes sense. All right. Good luck to you, Mr. Pena. Next is the case of the state of Ohio versus Denise Williams. This is case number 147. Present before the court is Ms. Williams, represented by Ms. Chambers. We have Ms. Nicholson from the prosecutor's office, Officer Richmond from probation. We are here today for sentencing. Has everybody had the opportunity to review the PSI, which was done some time ago, right?
I think it was. Yes.
Yes, there hasn't been a current one, Your Honor.
Okay. Any reason not to go forward with sentence today?
Your Honor, my client does wish to wait to have this stayed until the 25 case is brought forward so she can resolve both at the same time, if possible. So I've advised her of what that means and what that looks like, and that she'd likely be kept here or at the prison until that's done, but that's what she would like to do.
Okay. Any reason other than that not to go forward with sentence today?
No, Your Honor. It's my understanding the 25 case is currently set for a jury trial in March. We see no reason not to proceed with sentencing on the 17 case. They are unrelated, and she can begin serving that 17 case sentence.
All right. We have $4,000 in restitution and 140 days of jail time credit. Does that sound right to everybody?
Yes, Your Honor. Yes, Your
All right. Ms. Nicholson, on behalf of the state or on behalf of the victim?
Nothing on behalf of the victim, Your Honor. This appears to be a pattern by Ms. Williams. In addition, she did abscond from this court's jurisdiction for approximately 7 years. She delayed the resolution of that 17 case multiple times while it was pending in an attempt to get out from consequence for her conduct. She has repeatedly failed to take responsibility, although she did enter a guilty plea. She has failed to take responsibility or accountability, and we would ask the court impose the maximum prison sentence.
Anything from probation, Officer Richmond? Ms. Chambers?
Your Honor, other than what we discussed in chambers, I do know that Ms. Williams had an ill relative during the time that this was pending in 2018. I have spoken to previous counsel. Previous counsel was also aware of that. I mean, she would like to wait and get both cases resolved at this time, but she understands that may not happen. I have discussed that with her. But yes, whatever this court decides, she's going to abide by.
What do you want to tell me, Ms. Williams?
Your Honor, during that time, I was dealing with a very sick parent, my mom, and I was also working with outside sources, so the continuance were just not on my own, and I was trying to resolve both matters, and my mom ended up passing as well as my father within 6 months apart, and I just wanted to take care of both of them, but I've been grieving and going through depression, and I have a new grandbaby, and I'm just, if there's any type of restitution, I would like the opportunity to take care of it. I did reach out and I did search, and it said the case was closed. So I thought that it was closed. I reached out to another attorney, and he did call and he couldn't find anything. And I did look, and the previous attorney I did have said it did say close on there. So it was confusing to me. I'm not trying to take any more of the court's time. All this has just been confusing, and I've been trying to get my mental under wraps as well. And I reached out to Genesis and as well as Tower House.
So here's where we're at, Ms. Williams. I don't see these cases as being related in any way. I don't see any reason not to go forward with the sentence in the case that should have been over 6-7 years ago. I mean, you don't take any responsibility for any of this. We're going to have $4,000 in restitution that you're never going to pay back. I'm
sorry, Your Honor, I will pay it back. I do work, and I mean, I'm willing to be on probation for the rest of my life to pay. I mean, it wouldn't take the rest of my life to pay the restitution back. I thought that my insurance had actually paid it back, and my old attorney had looked it up, and he said that they never gave an amount because I was willing to pay it while I was out, and I thought it was $10,000. And I was told not to contact the dealership. I did contact the dealership one time, but then I was told not to contact her anymore, so I didn't. But $4,000, if you would just give me the opportunity, please, I could pay the $4,000. And if I don't pay the $4,000, you can send me away for life. I could be on the monitor and everything. I just, like I said, I have a new grandbaby and his mother.
I'm not doing any of that, Ms. Williams. I'm going to send you to prison today for 18 months. I think that to put you on probation is a useless exercise. I think that a prison sentence is necessary in this case to properly punish you and to protect the public. So I am going to sentence you to 18 months in prison. I'm going to give you credit for the 140 days that you have already done. I'm not going to impose a fine. I am going to impose the costs upon you. And we have this $4,000 in restitution. If something happens that you are able to pay the restitution in the case, then send me a letter and I will grant you judicial release if you can pay the restitution. I get that that seems very unlikely, but that's, you know, I do want to see Performance Lexus get their money, but I just don't ever think that's going to happen. This includes an optional period of post-release control. So that means the adult parole authority can, but is not required to supervise you for up to 2 years after your release from prison. If they impose that supervision and you violate the terms, you can be returned to prison for up to 1/2 of my original sentence. Or if you violate by committing a new felony, then you can be returned to prison for up to 1 year or the amount of time you have up on post-release control. It's automatically whichever of those is the longer period, and it's automatically consecutive to the sentence that you would receive for the new felony. You do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer to obtain the transcript or to pay the costs, they will all be provided to you at no charge. What I talked about, Ms. Williams, is I would keep you in the jail for a week if there was some thought that we might resolve the other case in that week and you wanted to think about it or talk to your lawyer about it. But that case is set for trial in March, and I do not intend to stay your sentence until then. We'll transport you back for the trial.
So what he was saying is if we were going to resolve the case in a week, he was going to keep it for a week and sentence the division was to take it to trial. He's not going to wait until March to resolve this. That's why he's resolving it today. If you pay the $4,000 in restitution, you can make a motion for judicial release to let you out. So if you have a way for that $4,000.
Ms. Chambers, you can just let us know after the hearing if that's what she wants to do. Just
Absolutely, Your Honor.
send me an email. I'll probably need to know by this time tomorrow.
Absolutely, Your Honor. I would send him.
All right. Are we ready on Ms. Clark's case? This is the case 25 CR 42958. Present before the court is Ms. Clark, represented by Mr. Moss, and we have Mr. View from the prosecutor's office, Officer Bridgman from probation. We are here today for sentencing. Has everybody had the opportunity to review the PSI?
Yes, Your Honor. Yes, Your Honor.
Other than what was contained in the motion for continuance, Mr. Moss, any reason not to go forward with sentence today?
No, Your Honor.
All right, we have, I thought I had it here. What's our jail days?
It's 8 days.
8 days of jail time credit. All right, as a preliminary matter, the court has provided Ms. Clark through her attorney with 2 documents. One is a notification on indefinite term, Reagan-Tokes. Ms. Clark, you're going to be receiving both a minimum and a maximum term. It's what we call a Reagan-Tokes sentence. It's presumed that you're released at the minimum term, but the Department of Rehabilitation and Corrections may, under certain circumstances, keep you up to the maximum penalty. You have something there called a notification Reagan-Tokes. I'm going to attach this to the sentencing entry as Exhibit 1. Do you want me to read this to you, or are you satisfied that you understand and have been notified about the Reagan-Tokes sentence? Next, we have post-release control. You're going to be subject to a mandatory period of post-release control of anywhere from 2 to 5 years. Same notification. Do you want me to read this to you, or are you satisfied that you understand? All right. Mr. View, on behalf of the state.
Your Honor, consistent with the plea agreement with the defense, as the court's aware, Ms. Clark has a prior history of trafficking, prior prison sentences imposed due to her drug trafficking history. And based upon that, I think in terms of the 4 cases, the state's recommendation is to count 3 that the court impose a minimum definite mandatory term of 8 years to a maximum indefinite term of 12 years, and that she received concurrent sentences as to counts 1, 5, and 7.
Mr. Moss?
Your Honor, we disagree with that sentencing recommendation. I've read for the first time here in the PSI, and I understand this. My client, this isn't something people like to talk about, her history of sexual abuse and trauma, which corroborates what I'm arguing is this is a drug addict who basically is on the spoke. There's a hub of drug trafficking, and then there are spokes, the people out in the street who do the transfers. Any funds obtained from that she used methamphetamine. She's a drug addict. And I looked through her PSI, and it's not, this isn't finding fault with anyone else, but she kind of slipped through the cracks in terms of rehabilitation. She'd be off the street during her time, but between the child sexual abuse and other trauma in her life, apparently she has a diagnosis of bipolar disorder, major depressive order, PTSD. So that you have a strong case of self-medication. I've seen many cases like this. When I was in New Mexico, I represented many females in similar situations. She was employed and she was released on bond and didn't have any dirty UAs, which is actually not par for the course. Usually they have all kinds of problems once they get out. But the one thread that ran through it, in my experience doing this many years, was sexual abuse. So I think that she's proven, first of all, it's a mitigating factor. Whenever someone engages in criminal activity as a result of trauma or some type of mental illness, it's different than if they're just profiting off other people's addictions. And in this case, Your Honor, I think the state's actions help support the fact that she's not dangerous. As I pointed out in my motion, these are controlled buys in which the state was involved in each one. And each time she was sent home, each time they set something else up again, sent her home again. If there was any threat that she had firearms or was selling contaminated drugs or trying to get people to overdose and die, she would have been arrested after the first thing. So I don't think the consecutive, I guess they're just asking for 8 years on one sentence, which makes it easier legally. But I would contend that in terms of protecting the public, a much lower sentence is needed. In fact, I think she's proven that through her actions in employment and staying off drugs, that she's not a danger at all, as long as she's supervised. The second half of this is what we've talked about prior to court, and I thank the court for being willing to consider staying the execution of the sentence. Is this person is at rock bottom in life. I don't know how more of a dire situation she could be in and still be present with us today. She's facing a life-threatening illness, which is going to require a lot of very uncomfortable treatments to even survive. So this is something she has to deal with, and she understands. She's always taken responsibility for her actions between her and I. Never once considered trying to blame anyone else or floating some type of defense. She's been a very pleasant client to represent. She also informs me, and again, this is a personal thing, her 8-year-old daughter's in Cincinnati Children's Hospital this morning. They're going to be going right there after this hearing, if the court allows it, she's in surgery for something involving her digestive system. So I'm having a hard time wrapping my head around what my client is going through. Your Honor, I would ask I know the court's already sentenced her twice, 3 times, but for drug trafficking twice. And she's let you down. But the PSI is recommending mental health treatment, residential services for mental health and substance abuse. I think that this should have happened sooner. It's possible we wouldn't be sitting here today. But I'd ask for a sentence far below that, consistent with the other sentences the court gave, because she's proven through her actions she's not a danger. And she's much less of a person physically than she was when she committed these offenses. She doesn't have the physical capacity to engage in more criminal conduct. And there's a lot of good in this person. There's an explanation now for why she was doing what she was, and her role in the offense was more of the spoke than the hub. And I understand this more now. So I would ask for a much lower sentence.
What do you want to tell me, Ms. Clark?
I just want to apologize to the courts. I've had a life-changing experience going through life, knowing that I might not have a life to live much longer, and I realized that I messed up my life. my whole life, and I've hurt the community. And, you know, I look at life a lot differently right now. And I'm really trying to do better. Like, I've gotten married. I'm in my kids' life. I have an awesome relationship with my kids now. I've never had that before. I have my family here with me today. Knowing the fact that you sit in a hospital, they tell you that you have cancer and that it's an aggressive cancer. And even if when I go through my cancer treatments and my chemo, that the likelihood of it coming back is very, very high. I'm scared. You know, all I want is my family now. I don't talk to anybody that I used to have contact with. I've completely changed my life. I've moved. I am now living with my mother. You know, I'm not in Warren County anymore. I've removed myself from the people, places, and things that I'm supposed to. I'm just right now just concentrating on my health and living every day that I have to be with my family and be positive and try to get myself together.
Ms. Clark, you and I have known each other for a long time. Sent you to prison for the first time back in 2013, back in the days when we used to still cook meth, and people would go around the community collecting stuff. It's been the same story, Ms. Clark, pretty much the entire time. And I don't think it is either fair or accurate for it to be represented that we have not done everything that we could do in our power to try to put you back on track. You were on probation with me for a while. We tried prison, we tried judicial release, we tried supervision, we tried everything that we could do.
And I'll be real honest with you, Honor. I wasn't ready then. I didn't care about my life at that point in time. I really didn't. I didn't care about shit, you know? And I'll be honest with you, not long ago, I still didn't care. But when everything got taken from me, like, and I got told that I could lose my life, that I could lose my leg, like, my thinking of stuff it scares me. It scares me to lose my life.
I don't want to minimize that, Ms. Clark, because I get what a life-changing experience that could be. And I mean, you know, I hope things come out okay with the surgery in your daughter. I mean, you were on supervision with me when you had your daughter. I mean, yes. I have a picture of your daughter right here in my notes from when she was born. So, I mean, we've been through life-changing experiences also before. This is just a punishment case, Ms. Clark. That's all it is. What I'm going to do is I'm going to sentence you to 3 to 4.5 years on each of the felony twos. They're going to be served concurrently with one another. So you have a 3-year mandatory prison term. It's presumed that you're released at the minimum term, but the Department of Rehabilitation and Corrections can, under certain circumstances, keep you up to the maximum penalty. I'm going to sentence you to 36 months in prison on the F3. I'm going to order that these be served consecutively, one after another, for a total of 6 years in prison. The F2s, the mandatory time will be served first, so you have to get that mandatory time out of the way, and then you will begin serving the consecutive sentence for the F3. We have an indigency affidavit, I assume, somewhere, Mr. Moss, right? Mr. Moss,
that's what I didn't get done with because I was out there talking.
Okay, where is it these days? Where we keep moving it around? I do find that you're indigent for the purposes of fines and costs. There will be no financial sanction in the case. You're also subject to the post-release control that we talked about a couple of minutes ago. It means the adult parole authority is going to supervise you, and if you violate the terms of that supervision, then you can be returned to prison for up to 1/2 of my original sentence. Or if you violate by committing a new felony, then you can be returned to prison for up to 1 year or the amount of time you have left on post-release control. It's automatically whichever of those is the longer period. I'm going to stay the imposition of this sentence, and I'm going to set this for a status conference sometime in June. I'm not going to continue to put this off indefinitely, Ms. Clark, but I do realize that you are probably at a critical point in your treatment. So you're going to continue to remain on supervision until that time with pretrial. Anything else? Anything I forgot?
Your Honor, maybe I misheard you, but the indefinite term on counts 3, 5, and 7 is 4.5. It's
3 to 4.5. Is that not what I said?
That's why I was saying. I wasn't sure if I heard you. I thought you said 3 to 4. I just wanted to make sure.
I'm sorry. It's 3 to 4.5. Because it's 1/2 of the.
Yes.
It's 50% of the mandatory term. All right. Anything else? All right. You do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer to obtain a transcript or to pay the costs, they'll all be provided to you at no charge. Mr. Moss, why don't you go ahead and give us a temporary bill in the case, but I do want to keep you on for the status conference. I don't want you to have to wait 5 months to bill for this case, though. So let's go ahead and get a status conference sometime in June.
Okay, thank you, Judge.
Okay? All right. Good luck to you, Ms. Clark.
Thank you.
All right. Are you ready for our Zoom? State of Ohio versus Zachary Arnett, case number 25 CR 43056. Did we lose Mr. Arnett? Can you hear me, Mr. Arnett?
It says they're connecting to audio.
Can you hear me, Mr. Arnett?
Yeah, I can hear you.
All right, this is the case of the State of Ohio versus Zachary Arnett, case number 25 CR 43056. We are here today for a pretrial, but it's my understanding that we're going to do a plea today. Mr. Arnett is attending via Zoom from the CBCF, and his attorney is here in person, represented by Ms. Hinkle, and we have Mr. View from the prosecutor's office. What's proposed here today, Mr. Arnett, is that you're going to enter a plea of guilty to 1 count of theft, which is a 5th-degree felony. We're going to set this over for another hearing, a Zoom sentencing hearing. My plan in the case is to do a pre-sentence investigation. Once I get that pre-sentence investigation back, the plan is to transfer your supervision to Champaign County and just follow along behind what Judge Salvaggio does in that case. Do you understand all of this?
Yes, Your Honor.
Are you okay going forward in this format today?
Yes, sir.
All right. How old are you, Mr. Arnett?
22 years old.
How far did you go in school?
I completed the 12th grade in juvenile facility, but I never got a diploma for it, sir.
Are you able to read and write English?
Yes, sir.
Are you under the influence of drugs or alcohol?
No, sir.
Are you taking any medications?
No, sir.
Are you a United States citizen?
Yes, sir.
Other than what we've talked about, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No, sir.
I have a document entitled Change of Plea and Entry. I understand that you have reviewed this document with Ms. Hinkle before today, right?
Yes, sir.
Is that your signature that I have? I don't know. Can you see that? Probably not. But you,
I got the stamped copy, sir.
okay. And are you satisfied with the representation that you've received in the case?
Yes, sir.
You're going to enter a plea of guilty to one count of theft. It's a fifth-degree felony, punishable by up to 12 months in prison and a $2,500 fine. If you don't successfully complete community control and I send you to prison, the maximum penalty also includes an optional period of post-release control of up to 2 years. I'm sure that the judge in your other case went over it with you very in detail, but I need to go over your rights with you as well, Mr. Arnett. You have the right to make the state of Ohio prove that you're guilty in this case. That means that you're presumed to be innocent, and you can't be convicted until every member of a jury is convinced beyond a reasonable doubt that you did this. You would have the right to confront all the witnesses against you in the case. You would have the right to compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to this charge, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the sentence. Is that what you want to do?
Yes, sir.
Mr. View, what are the facts?
Your Honor, if the case were to proceed to trial, the state would produce evidence beyond a reasonable doubt that on September the 20th of 2025 at Turtle Creek Township, Warren County, state of Ohio, at the casino, the defendant did convert to his own possession a wallet of the victim containing $200 in cash and credit cards.
Anything on those facts, Ms. Hinkle?
No, Your Honor.
Mr. Arnett, did you?
Approximately one payment so far.
County of Washington State of Michigan adopted back confession. The Honorable Judge Davis.
You may be seated. Back in the case of fixed housing, 401k plan versus the wards. Here's what I'm going to do, much to your dismay, because I'm going to give you an eighth date. Okay. An eighth date to come back, an eighth time. But I am adjourning the motions for summary disposition. I am also, after some consultation as to some of the ethics that have been involved, which is why I was taking the rather prolonged break, that I'm going to set an order to show cause for Donna Tope to show cause why she should not be held in contempt for the filing of this. I would just place Ms. Ward, I would place you on notice that you have made a specific representation to this court that you had no knowledge of any of that. And so I'm holding to that representation in terms of setting this notice or setting this order to show cause. Counsel for the plaintiff, in the event that the court would award sanctions and or costs, I would need a billing from you, an appropriate billing from you, laying out from certainly the time Friday time that you received this, what you had to put in to do that. And your work up to that, as well as what other stuff you may have to deal with this being adjourned out 2 weeks to that day. I will then adjourn it for the motions and for the order to show cause to February 3rd at, you wanted me at 2
p.m.
At 2 p.m.
Can I hear again what those two purposes are?
One of the motions that I'd like to rule on at some point, but the other is for an order to show cause as to why Ms. Tope should not be held in contempt of court and or sanctioned.
On that second note, how does that have anything to do with me and?
Oh, it certainly does, because here's going to be part of your problem, as it may be. And that is, I will have to make a determination if Ms. Tope gets here and says that that was filed with your full knowledge and authority, because you have represented to the contrary. And so I would suspect that when the two of you get here, you're going to be very much at odds.
So you're going to reach out to her separately, so I don't have.
Oh, no, yeah, we'll be sending a little piece of paper commanding her to be here.
But has. Wait. Okay, can I ask one question before you adjourn today?
Yes, ma'am.
Plaintiff's lawyer mentioned that I had reached out with 2 additional complaints. And I just need to understand what my legal process moving forward would be when I have a fence fall over or don't have water, because those weren't additional complaints from the past. Like, I'm still
You
there.
can certainly reach out with whatever, right, you can reach out with whatever repairs. I certainly would have been in a position to kind of address that today, but I
realize that my landlord is probably not, as usual, going to do anything about it, but I want it documented that, hey, on this date, the wind blew this section of fencing over. It just keeps happening. So that's okay to email him.
you can email him.
Okay.
As long as it's you emailing him. Right?
Yeah, it's no motions or anything.
All right.
Thank you, Your Honor.
Sir, was there anything else?
I would just say, when you email me, put that it's for this action, because Donna Tope is still representing you in the circuit court action. So be clear what you're talking about. Because there are two actions.
So regarding my lease, these things are falling over. Is that correct?
I think what he's trying to say is that you are directing your concern regarding this case,
right,
as opposed to the case that you are represented by Ms. Tope.
No,
Because presumably,
so
so listen to what I'm saying. That it's regarding this case, because presumably if the complaint were to be in that other case, he would be receiving a communication from Ms. Tope.
Okay.
I'm trying to make
yeah, right. Because he can't respond to you in a case in which you are represented by an attorney. So you have to make it clear that this is the case you're dealing with.
Okay.
All right, folks. Thank you.
Thank you.
And so that, I guess one other thing, I was not aware of that filing because it had gotten put into the file and there was no judge's copy that was presented to the court. So it did not come to me. But. Oh, that's right. You got to do that. What's this?
This is, yeah, all right, there. Thank you.
Thank you. Allen versus Hayes. All right, state your name. All right.
Your Honor, for the record, Walter White, appearing on behalf of the Mary Hayes defendant in this action. I believe we've resolved the case.
Okay.
Half a second to try to find my notes. This was an answer under a 30-day for possession of a premises. Just a little background. Ms. Hayes is rented from Mr. Allen for 13 years. Mr. Allen's got health issues, and so he's got to sell the property.
Yes.
And so he needs to get unit empty. What we've agreed to is as follows. First off, we want to adjourn this hearing to honor after about the 15th of April, whatever appropriate court date.
After 15th of April.
Yeah.
All right.
Honor about 15th of April. I recognize this is a 30-day, but we'd like to have Ms. Hayes be able to pay money to Mr. Allen without prejudicing his action necessarily, if we could do that.
All right.
She would be giving him $2,000 today, and then an additional $650, which is a month's rent, by February 14th, $650 by March 14th. If any payment she makes is more than 3 days late, he can apply for a written restitution. She will leave the premises by the 31st of March. If she doesn't leave by that date, he can apply for a writ of restitution. But if she makes all the payments and moves out by March 31st, he'll dismiss the actions. And that's the entirety of our agreement.
That a correct statement, folks?
Yes.
All right. I don't have a problem with the agreement. I don't know that I would need the adjourn date. You would typically, the way I'm understanding is this could be resolved by way of the filling out of an order of conditional dismissal. And that way the matter would be dismissed until such time as the matter would be conditionally dismissed. As long as you fulfill the terms, then the matter remains dismissed. If you don't fulfill the terms, then they can seek a judgment and an immediate writ. So I'm going to suggest to the parties that you take the time to fill that out. And Mr. White, you are representing which party? You're representing?
Who are you representing?
Oh, I'm representing defendant.
All right. So I don't need to advise her of her rights under 3-day rescission because she's represented by counsel. So they actually have the form out. They should have the form out front.
I believe so.
Of a conditional order of dismissal. You guys fill that out, make sure everything's checked on it, then it can come back to me. I can sign off on it.
Thank you, Your Honor.
All right. Thank you folks for working it out. All right. Take care. This is my last line. All right. Hold on now. Center Place versus Sigrid Melvin. Okay, see? Okay. All right, the parties are present once again. My understanding is what? That can you hear me now, Ms. Melman?
Okay.
Okay, very good. Okay, so my understanding is there was going to be a conditional order of dismissal with these terms, right? Ms. Melvin, did you get a chance to go over all of the terms on here?
Yes, we did.
Okay. You have any issues with any of the terms on there?
Yes, quite a few.
Oh, boy.
I talked with their attorney down through the items, and we've had our discussion and I've come to an understanding.
As to,
Agreement on the dismissal.
pardon?
Agreeing on the dismissal.
On a conditional order of dismissal? Okay. But these are the terms under that conditional order of dismissal. Is that correct?
Yes, we're going to just add a few words and I wanted to know. Right, so.
Okay. Go ahead.
About halfway down, so outdoor planting boxes are courtesy, etc. That come overgrown, my client will remove overgrown.
Okay.
And I want to add to that, I'll add it to my copy right here, after reasonable notice to.
Okay.
Other vegetables and ferns grow tall.
Yeah.
I can see something on it. And so, Judge, some of the plantings are not flowers, maybe they're not pretty, but we're concerned about weeds and things that
Correct.
get us in trouble when we have a hot inspection.
Okay.
My turn.
Hold on. What was the other thing? Was there another change of language?
Mr. Melvin, what else would you like? We talked about everything. There was some. That's pretty much it. I was just concerned, some are like fennel grows 6 feet tall.
Exactly.
It needs to be looking out box along the whack. Cut them are hard work. I have all your answers, answer all your questions until we had lunch. Trust me.
Oh, okay. Yeah.
All right. Was there anything else in that regard? Okay, yes.
I guess I have one question. Since it's not on a court ordered paper, how legal is this? Because it only says 14 and doesn't have the case number.
It will, because there are other parts of that document in terms of a conditional order of dismissal.
Oh, okay.
Okay. And so basically what will happen is the case will be dismissed conditionally.
Good.
Okay. As long as, and you're doing it under all three case numbers, or
Can I put all three in the corner?
that'd be fine.
And I told Mr. Melvin, I will show this to him in the standard scale form.
All right. And it's a standard form. Or is it going to be a 4A or 4B case? Are they going to be entitled to a hearing?
I'll leave that at the discretion of the court.
I think it should be a hearing. She should have the right to a hearing, notice of hearing. All right. Okay, Ms. Melvin, you understand that? So the case is dismissed at this point, but it's conditional.
Okay.
So as long as you follow all of these rules, okay? You can do it. I know you can. All right, as long as you follow all of those rules, then the case just stays dismissed. Hold on, if there becomes a problem, then they've got to give you notice of what the problem is. Then you get to come back and see me.
Okay.
We like you.
Now, I've been in that building since 2006.
You know what? I know that because you tell me that every time you come here and see me.
Oh, okay.
I know I know how long you've been there. I almost feel like I've walked through your tenancy with you.
Okay, I'm thankful for that.
Yeah, all right. So you follow these and do that. And so come this spring, when it's time for plants, just make sure that you have the right number of pots out on your balcony. Remember, and the other thing is no hanging from the top.
Yeah, not even the American flag. Is that nice?
I don't know about that. I was only dealing with plants. I'm not, Ms. Mel, you are not going to lead me down that path. All right. But no hanging pots can go up on that. Okay.
Well, we'll see. Okay.
Okay.
Judge, the 3-day rule,
Yes, I will apprise them of that momentarily.
I'll check that.
Yes. All right.
Sign this. I've signed the addendum also, just,
Yes.
presented to. This is the official court form. This is where the defendant signs and dates. The substance of our agreement is right here.
Oh, look,
And I've signed it, you can also sign it.
Oh, that's a court order. Okay, thank you for the correction.
Here's the case number.
Okay, that's fine. No, it's just, oh, it sounds like, okay.
You're done.
Okay, yeah. Okay.
Conditions. Okay. Now, this is the last page. Sign here. This is his signature. Judge Simpson's gonna sign that. Okay, got it.
What do you want to
Oh, yeah.
Hey, Judge, you want to hear something funny?
Okay.
Since they're stalking me all over, guess what? They even follow me into my bathroom. Because when I flush the toilet, they know about it because the toilet comes on every 2 seconds. So they stalking me.
They're stalking you. Okay. Maybe they'll stop that. Okay. I gotta tell you one other thing. Okay.
Yeah.
Okay. That I'm gonna sign this. Well, first of all, I'm gonna ask you got any questions regarding any of this?
I've got another question.
Well, do you really?
Like the one that says I called the fire department?
We had a conversation about that.
Oh, really? So does the judge know that?
Both instances were resolved by the door motor being replaced, wiring in the wall, the fan in the bathroom that was smoking, blowing sparks out. That motor was also replaced.
Okay.
I did go over to the fire department, talk to the fire marshal, and I asked him, I explained what happened, and he said they had no problems or issues, as far as her, creating a felon or,
Great. Okay.
unwarranted calls.
Okay. All right. Very good. Okay. So.
Yeah, I had a flood from the 5th floor coming down. It flooded my front door, the back door, the hallway to the bathroom.
Okay.
No help came from the office. They wouldn't even let me have the vacuum cleaner to suck up the water.
Okay. Well, maybe, Ms. Melvin,
I
maybe,
know what to do.
right, it'll get better. Okay, so if those are the questions that you have, now the next thing is, I do have to apprise you of this. You have 3 business days from the time that I signed this to think about it. If you think that there's some mistake that you made, some confusion you have regarding this, or some right you did not assert, you would have to file a motion with the court within that time frame.
3 days?
3 business days. Okay, but you understand that even if you do that, that doesn't mean that I would set this aside. I would hear you, but it doesn't mean that I wouldn't then end up just denying that and hold you to this. You understand that?
Okay, do you understand that? Yeah, okay, sorry.
You understand? No, it's okay. It's okay.
Okay, then. Thank heaven for my son.
Yes. Yes, indeed. I think he has been very helpful to you in terms of trying to get this resolved.
Because all the agencies I called, your fair housing, Virginia. But the 2 ladies were here, but they never got to talk.
Well, listen, here's the thing. I don't know if you remember this, but you told me one of the first proceedings that you had a son. And you kept telling me, you were saying very proud things about him, but you didn't want to bother him too much about it.
No.
And I kept trying to encourage you. I had a feeling, I don't know your son, or didn't at that time, certainly. I just had a feeling that if you called him, he was going to be there to try to help you out. And
He's been here around my house for the last 2 months.
yep,
He's even taking time off from work to help all this stuff.
She didn't call
Yeah.
yeah, it's true. She
me.
did.
The lady from,
Oh, that's right.
Yeah, she's the one that called me.
Yeah.
Yes, I went over with a bunch of people and had storage containers. No, they were gonna do was put everything she had in storage containers and stack it out.
Right.
You see the difference after I got the books out.
Yeah.
And yeah,
Well, however you got there, thank you for stepping in.
Well,
Okay. Appreciate it.
I have, thinking back how I got into this position. Well, I contacted nonprofit, LSSCM.
Legal services.
And we had an interview in the office with a lawyer came on. He never explained what was happening. So next thing I know, I'm at my doctor's office and the social worker there asked me to come to this room and watch this on Zoom. So I don't know how it went from there. Then I had a knock on my door Labor Day. The young lady said she's from the state of Michigan and she's just gonna come see if I'm okay or something. Well, the next thing I know, it's the state of Michigan and to 4 people and a federal marshal to move my stuff. What the hell did I do?
You know what? I understand it causes you great frustration and just hold on a minute, okay? But out of all of that, sometimes there's a great blessing and great joy. And I can tell you for me, this case has been kind of tough trying to figure out everything, counting flower pots, doing all that stuff off a balcony and all those things. But one of the blessings and great joy is I got to see my good friend, the attorney here on this side. But also the great blessing is that I got to meet you.
I lost 30 pounds and my blood pressure is 100 over 200. So I'm very fortunate here.
Yes. And so I will always consider that a blessing, Miss Melvin. All right.
I'm 84 and I'm going to be great grandmother in the next 2 weeks.
Are you? Well,
Yeah.
Congratulations.
Heaven loves me.
Yes, indeed. And you don't look 84. I would have pictured maybe 29. All right. You guys take care.
One more question.
Yes, sir. Yes, ma'am.
For the
When do I pick up phones at the desk?
For, oh, you don't need to file that motion. You just have the right to do it.
Oh,
I don't think, I mean, you can do it if you want, but I don't think that you need to, given how this is all worked out.
okay.
All right?
Thank you.
You're welcome. You take care of yourself.
I bet nobody else will.
Thank you for your patience.
Not a problem, sir. Thank you. Mr. Rosberry, thank you, sir.
Oh. That's wondering why it was long. Thank you.
Thank you. Judge, copies will be mailed?
I sent them out. Yes, they should be mailed out to you.
Okay, thank you.
All right, thank you. Ready? D Squared Partnership versus Eco Lawns LLC. Council, take your appearances for the record, please.
Good morning, Your Honor. Dean Troy, on behalf of plaintiff, please swear.
Good
morning, Your Honor. Pascalio, on behalf of defendant, Ecolon.
All right, and I guess with used to, I don't get afraid to ask this. Where are we on this?
Well, we're just, I think, really looking for a scheduling order. One thing I did want to do is we were able to work out the terms of the escrow order. Your Honor, granted escrow at the last hearing.
Yes,
We haven't yet submitted an order.
I was just looking for that. Pardon?
Can I submit an order here?
Yes, you can submit it here and I'll, if it's agreed to by both parties, then we're good.
I'll drop this here. Thank you.
Okay,
Oh, sorry. Thank you.
they pay attention to you. You turned right around. All right. Go ahead.
So for the escrow order, we are all agreed on that. We have paid as of the 16th. I know that we're submitting this on the 20th here. The first payment was made to the court for the 5,000 and change for that first payment under escrow.
Right.
We were informed by the court that it is a cash only system unless Your Honor grants alternative forms. Given the monthly rents that we are going to be dealing with, we would request that Your Honor allow us some alternative form of payment into that escrow besides cash, so that
yes,
I don't have to show up with
the
amount of cash every month.
it would typically, it's going to have to be cash or certified funds for us. Would it be getting a certified check would not be a problem? All right. And I will note that.
Thank you, Your Honor.
All right, so I will certainly permit that. All right. Were we able, there were certain issues regarding the heat, I think, in the premises. Were we able to get that resolved and everything?
It's hard to know. They are at the moment. I believe we have been out there, and so the order that we just submitted to Your Honor does have provisions requiring maintenance of heat of 50 degrees.
Yes.
And as far as you know, since last time we were here, there have not been issues.
Okay. All right, great. I think the last time we were here, we were in that January or whatever thaw. So I thought, don't worry about it. It's not going to get that cold. Then today happened. All right. All right. And in terms of scheduling, what are you guys looking at trying to do here?
We are for ourselves looking for a trial as soon as the court will permit.
All right. What's your position?
I mean, I don't think that we have necessarily a reason for delay. This is just a summary proceeding in possession. There isn't a claim for the rent itself as it exceeds the jurisdictional limit at the moment. So we've presented our defenses. I think a pretty quick schedule is,
Okay.
we are not opposed to that.
Well, and so all the parties have what information they need, or at least can cooperate in making sure that.
I believe so. Yeah, I believe we can cooperate in getting that information exchange. I mean, I will again put on the record, I think that this is a case that is ripe for some sort of facilitation, whether before this court or a formal mediator. I am not opposed to that. I understand that we don't have a current order on that. I would welcome it.
Well, the way I do it is that usually I have the parties meet with me. Actually, I did set this for a final settlement conference because you may have mentioned that to me the last time. Are the parties close, not close? Where are you?
It turns out to be a hard question to answer. I had some very productive conversations with other counsel, but I just can't say. There are some issues that go beyond possession that we have a fundamental disagreement about. So I have not been super optimistic about mediation or settlement. That being said, we have an open channel of communication and we'll continue to talk.
All right, here's what I'll do before setting in a trial date. I understand that the parties may want a trial date, but I want you to kind of get all of those things together. Usually I find with you two that you two attorneys are some of the most reasonable attorneys I get to deal with. Clients can be an issue, but what the heck, right? So what I would like to do, what do I have?
Well, your next date's the 10th, February 10th.
February 10th. What did I set? Just did I set the horse people back? No, February 10th.
That's on the 3rd.
Okay. So what I'm gonna do, counsel, is I'm gonna set another final settlement conference in this matter for February 10th, you said?
Yes.
February 10th, 2026. Again, I'm going to set this one at 11. I don't want a lot on that date either. Okay. And that way I can have some time to talk to these gentlemen and see if we can hammer this out and reach a resolution. All right.
Thank you.
Thank you, Your Honor.
All right. Thank you, folks. Do appreciate it. It was good seeing all of you. And Troika, since I've known you the longest, it's always good seeing you, sir.
Your Honor, could you tell me how long I look?
To 2 years. If you violate that supervision, the adult parole authority can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time that you get sentenced to. Do you understand that?
Yes.
You are presumed innocent of these charges. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes.
You have a right to trial by jury. If you want, we will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty. Their verdict must be unanimous. Do you understand that?
Yes.
At that trial, you have a right to see and hear all the evidence that the state has against you. With the help of your attorney, you have the right to confront and cross-examine each of their witnesses. Do you understand that?
Yes.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes.
You have the right to remain silent at your trial. You cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you. And I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes.
The burden of proof is on the prosecutor at your trial. You're not required to call any witnesses nor present any defense. And if you do not, that will not be held against you. Do you understand that?
Yes.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of each charge from the indictment. Do you understand that?
Yes.
You could also waive your right to a jury trial, but maintain all the other rights we've discussed. You could try your case to the court. I too would have to be convinced of your guilt beyond a reasonable doubt, or would be required to find you not guilty. Do you understand that?
Yes.
Do you believe you understand each of these rights we've discussed?
Yes.
Do you understand that when you enter a plea of guilty, you'll be waiving all these rights? We will not have a trial.
Yes.
This is how you wish to proceed.
Yes.
Ms. Hyatt.
Your Honor, if this case had proceeded to trial, the state would have shown beyond a reasonable doubt with respect to counts 1 and 2 that they both occurred on October 20th of 2024 while this defendant, Tiffany Oney, was at the Monroe Outlets in Monroe, Warren County, Ohio. With respect to count 1, during the investigation there by Monroe Police of a theft investigation, she did knowingly possess a controlled substance. In this case, it was 0.16 grams of methamphetamine, a Schedule II controlled substance. And with respect to count 2, she did knowingly have in her possession merchandise from the Adidas store there at the Monroe Outlets that she had been seen concealing and left the store without paying and without the consent of the owner. The merchandise was came to $215, and it was all recovered.
Ms. Hinkle, anything on those facts?
No, Your Honor.
Ms. Oney, did you hear the statement that she read?
Yes.
Do you admit that what she said is true?
Yes.
And again, you understand all the rights you're giving up entering a plea of guilty?
Yes.
What's your plea?
Guilty.
The court will make a finding that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we've discussed. The court accepts your plea of guilty. Based upon the statement of facts in your plea, the court will make a finding of guilty. Ms. Hyde, anything you want me to consider?
Nothing more than just the agreed sentence, Your Honor.
Ms. Hinkle?
Thank you, Your Honor. After speaking with Miss Oney, this incident did happen back in October of 2024. Since then, she's really been trying to get her life together. She's been clean and sober since July of 2025. She's been in the honors dorm and she's been in multiple programs while being at DCI. She does take full accountability for her actions, and she would really just like her to get her life back on track now.
Okay. Ms. Oney, anything you'd like to say?
No, sir.
All right, the court has considered the statements made here today, the purposes and principles of sentencing, the relevant seriousness and recidivism factors. The court has considered the agreed recommended sentence of the parties and finds it to be an appropriate sentence. So I will sentence you to 10 months in prison. Looks like you have 19 days jail time credit on this case. The 10 months that I'm ordering will be ordered served concurrent with your current sentence. Since there's no restitution, the court will make a finding that you're indigent for the purpose of any fines, costs, or other financial sanctions. Now, you're also subject to this discretionary post-release control. Do you want me to go over that with you again?
No, I understand.
All right. You have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, including an attorney, all of that can be provided to you at no cost. There may be opportunities for you to receive up to 1 day per month for participating in certain education, vocation, or other programs sponsored by the Department of Corrections. Ms. Hyde, anything else?
Your Honor, just for the record, count 2 is an M1. Did you want to just do
Oh, I'm
180?
sorry. Yeah,
No,
I'm sorry. Yeah, didn't write that down, but yeah, I'm going to order you to serve 180 days in the Warren County Jail. Obviously, that will be served concurrent with your 10 months.
Thank you. That's all I had, Your Honor.
Thank you. Good luck.
Thank you, Your Honor.
Thank you.
You have to speak out.
Yes, sir.
Here. Okay. Okay, there's an agreement that's been reached where you're going to be pleading guilty to a lesser included offense of what?
Criminal trespass, Judge.
Yeah. Okay, there's not a doubt that that's, I see assault, a lesser included assault is in here, but that's going to be,
Intentionally knowingly enter a habitation without the consent of the owner. That is criminal trespass, Judge.
and that is Class B misdemeanor.
Correct, Judge.
Yes. Yeah. What's the word on getting new pads?
No, I was just thinking about that this morning, Judge. I have not heard recently, so I will double check on that. Exactly.
These babies, you write and it doesn't show up on the pad until about 10 seconds after you've written it. Which. All right, agreement has been reached by the parties where you would be prosecuted and you would move forward on a plea of guilty to the lesser included Class B misdemeanor of criminal trespassing, which carries with it up to 180 days in the county jail and a fine up to how much on a Class B? $2,000. Is this your understanding of the plan? And do you understand fully the punishment range you are facing here for this lesser included misdemeanor? Speak up so she can hear. Yes?
Yes.
How do you plead to this lesser included Class B misdemeanor, sir? Guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence?
No objection.
And without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been wrote to you. You've read it. You were guilty of the crime charged in any lesser included offenses, and you were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God. State's Exhibit 1 is part of the record for all purposes. Pre-sentence report is waived here.
Yes, sir.
I'm going to follow this agreement, if nothing further to add, and find that Mr. Livings, you are mentally competent to enter this guilty plea. It is freely and voluntarily made. You know and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in this hearing here to find you guilty beyond a reasonable doubt. But we are going to defer any finding of guilt. How long can I place up to deferred on Class B misdemeanor?
Actually, Judge, I need to correct myself. It's a Class A misdemeanor because it's a habitation. And with any misdemeanor, the court has the authority to go up to 2 years.
All right, we're going to have to backdate everything here and go back. Sorry, this is a Class A misdemeanor, not a Class B misdemeanor. That's got to be corrected. Which carries with it up to 1 year in the county jail and a fine up to $4,000 can be assessed. Do you understand that punishment range, sir?
Yes, sir.
That's what you're facing, not the Class B that we talked about. do you still insist on making your plea of guilty in this case based upon what the court has stated to you?
Yes.
All right. Then I'm going to follow this agreement and find the defendant has pleaded guilty again voluntarily, knowingly, intelligently to this Class A misdemeanor, lesser included offense of criminal trespass. Even though there's enough evidence to find you guilty beyond a reasonable doubt from this hearing, the court is going to instead defer any finding of guilt and place you on deferred or unadjudicated probation for 2 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. You will have no contact with the victim in this case. So I don't know what the underlying circumstances
I would
here.
I would agree that that's appropriate, Judge.
How did you know this person?
It was my sister's best friend's mom's boyfriend.
I'd have to have a roadmap to follow that one. That's 4 degrees of distance from a direct relationship, though. Nonetheless, is all that being fixed
Yeah, yes, sir.
responsibly and legally?
Yes, sir.
Okay. Make sure you follow these terms and conditions of probation. If you fail, your probation could be revoked. You could then be found guilty and sentenced up to 1 year in the county jail. Okay. Please see this lady. Thank you very much.
Sorry about the mistake, Judge.
It's okay. Judge, Mr. Walker, you got.
Judge. You don't go ahead.
I think y'all can work together and do a lot of damage as a team. If you want.
You do a better job than I did. I know, right?
Okay.
So get home and no, you good. You don't the job, man.
So what are we doing with Mr. Gavin?
Set for trial.
Okay. You understand this will be set for trial. You understand what you're facing here. If found guilty, right? Mr. Galvin, does he speak fluent English?
Oh, yes, sir.
Oh, okay.
Yes, sir.
All right. This is what there was an attempt to try to resolve this.
I think it's news to him, Judge, and kind of in shock right now. I'm going to explain it to him.
Okay. It'll be set for trial. If y'all change your mind, let me know on how we dispose it. But otherwise, like you say, it's almost 2 years old. It needs to move forward one way or the other. Okay. Please get a reset. Thank you. Yes, sir. Otis Pollard.
He's here.
Two cases. You're Mr. Pollard?
Yes, sir.
Pollard?
Yes, sir.
The accent is on the first syllable. All right, you're charged with 3rd-degree felony of unlawful possession of a firearm by a felon in 25 CR 138. And in 25 CR 139, that indictment alleges that you committed the state jail felony of theft. So you were looking at up to 10 years in prison in one case and up to 2 years in state jail on the other. So that's serious. What are we going to do?
Just gonna have just one more announcement on him, and I'll be ready. Just one.
How much time is that?
The normal, whatever your normal is.
Well, you're in the criminal district court. There is no normal in this building, in this room, as you know. Is 4 weeks good?
That's cool.
Oh, good. Thanks. Chastity Rashton. Get a resetting.
That's going to be disposed of. I think the state is taking care of that.
This is going to be refiled to a misdemeanor.
Okay, there isn't a lesser included we can do on this?
No, Your Honor. Not with the way that it's alleged in the indictment.
Yes. Okay.
Okay.
We'll do 1 week. They give them time to do it. That'll be enough time.
Well, this is just a review. You're going to end up doing it in misdemeanor court, right?
That's fine.
Is that right?
Yeah.
We would just need to place this on a docket for dismissal once the misdemeanor is pled to.
What we're gonna do is just put on a review docket in 2 weeks. That's fine. 2 weeks, so we can know it's gonna be done.
Thank you.
Thank you. And Paris Ross.
That's sentence.
Get a resetting, lady, madam, right there. Thank you.
And just in sentencing now, I have just two character witnesses, his mother and his sister, and it's not gonna be long. But he's here, and that's Mr. Ross, and then his mom and his sister is to the left and the right. Just come on first row. And this is sentencing. We did review the PSI too.
Number highlighted up to one, please.
All right, we call 2 cases. 25 CR 381. You are Paris Ross. So, and you are charged in 381 with fraudulent possession or use of a credit card, and that is a second-degree felony, which carries with it up to 10 years in prison, 20 years in prison. I'm sorry. I was looking ahead. You are charged also with 25 CR 382, the third-degree felony of forgery of a financial instrument, and that carries with it up to 10 years in prison. And looks like these were committed on or about the same day in October of 2023. He hadn't entered his pleas yet.
He did. Yes, he
He
did.
already did? Okay.
Mm-hmm.
Because it.
December 3rd, Judge.
And we got the PSI.
All right, a pre-sentence report has been prepared on each of these cases. Have the parties had an opportunity to review it? Are there any corrections or changes to it?
Yes, sir.
Go ahead.
The first correction is on page 1.
Which?
And that's defendant's version. And under defendant's version, where it has on here about denied participating in the offense, that's a correction for us because he's saying that he admitted to the offense, so that's a correction. And then the other correction I think would be on page 5.
Hold on, let's deal with that. First one.
That's on page 1, and that would be under defendant's version where it had denied participating in offense.
He
That's a
admitted.
correction for us.
Okay, this is line 5 under defendant's version.
Yes, sir.
Well, we got to go up some too, because he claimed in line 4 of defendant's version, the defendant claimed ownership of the items to prevent a female he was dating from getting into trouble. He goes on to state he admitted he was aware the items were connected to fraudulent activity, but denied participating in the offenses. He further stated he has learned not to take on other people's problems and not to place himself in harmful situations, and that his outlook on life has changed since the birth of his newborn child. So you're skipping around responsibility. You're either guilty or not guilty.
I take responsibility, Your Honor.
Is that your final answer?
Yes, sir.
and he's gonna want to correct page 5, 1, 2, 3, third paragraph, beginning in factors. And the correction for that third paragraph that begins with factors warranted, where it says, maintaining that he did not commit the offense while acknowledging that he was aware of the illegal activity taking place. He's saying that he does take responsibility for the offense. So he wants to correct that sentence in the PSI.
Can he correct what is the recommendation of the pre-sentence investigation?
No, he can't correct that. He can only correct what he is.
That's what he's proposing with that last suggestion, Judge. And I would believe that Ms. Carthen is only responding to what occurred to her personally. And since I wasn't there and Mr. Adams wasn't there, I don't know how we can correct that.
Okay. Taking one problem at a time here.
Yes, sir.
The defendant admits responsibility to each of these two offenses for which he has pleaded guilty to.
Yes, sir.
That's your final answer, correct?
Yes, sir.
Okay. All right. And denying participating in the offenses, why would you say that? Were you confused or something?
No, sir.
You were being dishonest with him? With the probation office? You denied participating in the offenses, is what you told the probation office.
Yes, Your Honor. I was in assumption like he was thinking that we used it or did anything with it. We didn't.
Okay. You've talked to your attorney about the elements of this crime, what constitutes each of these crimes, and you either acted as a party legally to this or you were solely responsible. Is
Yes,
that
sir.
correct?
Yes, sir.
Okay, in each of these two cases.
Yes, sir.
All right. What was the second part?
That was the only other
No, the second part that Mr. Hammes has an issue with.
No, I was just trying to correct page 5.
They're trying to change the comments under the recommendations on page 5, third paragraph down. He's suggesting that the last sentence be altered because of the change in his position today.
This thing, you mean where he did not accept responsibility?
Yes, sir.
Yes, sir. Where it says maintaining that he did not commit the offense, acknowledging blah, blah, blah. I'm asking that that be corrected because he's saying that he did accept responsibility. So that was a correction because you had asked me if you had any corrections.
Okay. Well, as far as this court's concerned, it's never too late to accept responsibility for culpability in a crime unless it's too late after the judgment has been entered. But if he wants to correct something, the court will consider it and allow it because what we're trying to get to is what is the truth?
Yes, sir.
Is that the truth?
Yes, sir. I take full responsibility.
All right, there's an agreement that's been reached here where for each case, a cap of 4 years in prison. I guess to run concurrently.
Yes, sir.
All right. So we are looking at no less than 2 nor more than 4 years in prison.
Yes, sir.
We are looking at up to 4 years in prison and then found guilty, and then he could be placed on regular probation for up to 10 years.
Yes, sir.
And then there's deferred or unadjudicated probation.
Yes, sir.
Which this court can assess, which would be up to 10 years can be up to 10 years in length. Are there any other options the lawyers can think about here in disposition? All right. I want to ask you about this. Were there any other issues to be dealt with the proposed pre-sentence report?
That was the main thing that I saw that I wanted to correct. Other than that, I didn't really see too many other corrections.
From state?
None from the state, Judge.
All right. I want to get a grip on one thing, criminal history here. Anybody figure out exactly how many convictions he has here? Because it's a little nebulous as I'm reading this, and it's not the probation officer's fault. It's just the defendant has been busy making bad mistakes for a long time, since 2008, actually, according to this. So we're talking about
I think
15, 16 years.
I thought, Judge, you were going to go to the misdemeanor that purportedly received a 12-year probation period, which I don't think is viable.
Okay, we start out, we're going to start from the beginning of issues on page 2. On July 2nd, 2009, it states the defendant was convicted and sentenced to 12 months probation for driving without a valid license. Is that true? That was out of Fulton County, Georgia.
Yes, sir.
Okay.
2009.
Yes, sir. But it says it runs concurrent with the prior sentence. I don't see another prior sentence in the misdemeanor court history, but I do see one, armed robbery. In 2008, you were convicted, 1 year confinement, 9 years adjudicated probation. So that must be what they're talking about. Those two, the misdemeanor ran with that felony, I guess. Also, you had a hindering apprehension or punishment of a criminal in Fulton County, Georgia, also on September 25th, 2008, and were sentenced to 1 year confinement, probated for 4 years. And that all occurred about a year before you were convicted of that misdemeanor. Then thereafter, that misdemeanor conviction and your 2 prior felonies of armed robbery and hindering apprehension, it looks like you were convicted November 2009, 7 years probation for burglary. That was revoked and you were sentenced to 3 years in prison in 2016. That true?
Yes, sir.
And also on November 25th, 2009, you were convicted and sentenced to 7 years probation, which was revoked, and you received 3 years imprisonment on the same date the burglary revocation and imprisonment occurred. And on this one, it was illegal possession of tools for the commission of a crime. I guess burglary tools, I guess. That was revoked and you were sentenced to 3 years as well to run, I guess, concurrent with the burglary. Then kind of backing up a space. In July of 2009, you were convicted and sentenced to 5 years probation for theft of receiving stolen property. Is that true?
Yes, sir.
So that means 1, 2, 3, 4, 5 felony convictions as of 2009 and 1 misdemeanor. But then In 2016, you're convicted of 3 forgeries, sentenced to 90 days confinement to run concurrently. And I don't understand, that is under felony history, but was that a felony or were those felonies or misdemeanors? Does anybody know? He's asking 90 days confinement. I mean, that would be a misdemeanor in Texas, but then 2021, you're sentenced to 6 months confinement. And that was adjudicated for 2 years probation for selling, giving, or transporting marijuana out of California. Is that true?
Yes, sir.
And in 2023, which would have been in June, you were sentenced to 15 days confinement for evading arrest or detention with a motor vehicle out of Harris County, Texas. Those are, some of these are coming up under the adult felony history, and that might not be right.
My NCIC report indicates that the South Carolina offenses are felonies.
Talking about
The ones that he received 90
Harris
days.
County and California.
Okay, so the question,
Oh, wow.
sorry, I was trying to answer for your honor is there were 3 convictions in 2016 where we received
Right
90
out of
days.
South Carolina.
Those are all felonies according to the NCIC.
And
I'll
then
check.
we've got,
I'll check the Harris County on that report.
and we've got to round out the field here, 2 more convictions, which are listed as misdemeanors. One in 2023 out of Harris County, Texas. You were convicted, sentenced to 3 days for assault of a family member. And then,
All right, Judge, I'm sorry, but Harris County,
yeah,
the original offense of evading detention was apparently pled as an eluding. So that should not be a felony. It should be a misdemeanor. That's the last one that has an offense date of June 2nd, 23.
okay.
And I'll check.
Say that again now. What did?
The evading arrest detention with vehicle that was offense date 12/17/20
Yes.
was disposed of on June 2nd, 23 as a misdemeanor offense of fleeing a police officer or eluding, as I like to call it. That is why it's a 15-day sentence there.
Okay.
And
that makes sense.
I will check the California.
Okay. We've got I'm doing this in a chronological sequence. He's convicted in January of 23, 3 days confinement out of Harris County. That's a misdemeanor in Harris County, Texas. Then finally, he was convicted and sentenced to 13 days confinement for theft by conversion out of DeKalb County, Georgia. And that was a conviction on February 2024, but yet it states the date of offense is a decade before that happened. See, it states the date of offense was June 2015, and he was convicted 9 years later. That's weird, too.
That's Georgia's history, Your Honor. Is that correct? Is that what I'm looking at?
Mm-hmm. All right. So. We add all this up. We've got a total number of convictions here of 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. Is that about right? 4 of which are misdemeanors that we know are misdemeanors. Others are apparently felonies.
The California case is a felony. I confirmed that through NCIC, Judge.
Okay. And here, each of these 2 cases occurred on that we are dealing with the sentencing on, the forgery and the fraudulent use of credit or debit card, 3rd degree and a 2nd degree respectively. Is this event, each of these events allegedly occurred in Jefferson County on or about October 19th, 2023. Which would have been just a few months after he was convicted and sentenced out of Harris County for that evading arrest or detention on June 2nd of 2023.
I did confirm, Your Honor, from NCIC that 9-year time frame on the Georgia offense is accurate. He had a warrant outstanding during that time frame for not appearing and finally dealt with it in 24.
Okay. All right, anything else anyone needs to change about in this pre-sentence report, especially under the police court version, defendant's version, or any other parts of the criminal history? Yes, no?
No.
No from the defense, no from the state?
No.
All right. Go ahead. Again, the agreement reached is whatever sentence shall not exceed a cap of 4 years in prison.
Okay, look, I need to cook. I'll be brief with you.
Okay, you want to
I just
present something first?
Yes, sir.
Who do you call?
Ms. Cook, would you state your full name for the record?
Lawanda Baggett Cook.
Raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Lower your hand. Go ahead.
All right, Ms. Cook, you currently live in Georgia, right?
Yes, I do.
And your son lives in Georgia, right?
Correct.
Who's your son?
Harris Ross.
Oh, okay. So we don't know.
Oh.
We're just learning. I don't know your family situation. The defendant is your son.
Yes, he is.
Okay.
Repeat that for me.
Would you spell your name for me?
Lawanda, Lawanda. Maiden name is Baggett, B as in boy, Aggett. Married name Cook, Cooke.
So, as I was saying, you're my client's mother, right?
That's correct.
All right. And you understand with the plea bargaining agreement today
he's been charged with 2 offenses, the fraudulent use of credit and debit card abuse, as well as the forgery of the financial instrument, right?
Correct.
And you understand that the plea agreement is a cap of 4 years where the judge could consider probation, right?
Correct.
All right. So to get straight to the point, you're familiar with your son's criminal history, aren't you?
Learning, yeah.
Right. And you're familiar with his character and who he is, right?
I am.
All right. The reason I brought you up here is that your son is your special caretaker, isn't he?
He is.
And I know it's hard for you to, talk about that, but you have a very serious ailment right now, right?
Correct.
And what is that serious ailment that you have right now?
I'm dealing with stage 4 cancer.
So you're dealing with stage 4 cancer, is that right?
Correct.
And with that being stage 4 cancer, your doctor has basically diagnosed you as dying, right?
Told me to live my best life.
Live your best life. Well, I mean, I'm just saying.
He said to go live my best life.
Live left, right.
Well, I mean, that pretty much takes a lot of hope out of things, but.
No, I'm just saying.
But
I'll explain why. And with you going through.
So you are being treated
I am.
medically?
Yes.
Okay. How long have you been experiencing this ailment?
I've been sick the past 5 years, December 13th, 2020.
Yes, ma'am. Okay.
So with you being in Georgia and with the stage 4 cancer that you have, is your son a provider for you?
He's the main provider.
And by the main provider, how is he the main provider?
He's making sure the bills get paid, making sure I get my medication, making sure I get to my appointments.
So at the end of the day, we know about his history. We know about the offenses that are charged. Are you begging the court for mercy today?
I am.
And are you asking the court to put him on probation today?
Yes. Yes, I am.
And without me putting words into your mouth, I want you to speak to the judge in your own words and tell the judge why you want probation for your son.
Good morning, Judge. My name is LaWanda Baggett Cook. I'm the mother of Paris Jawan Ross. I am dealing with stage 4 cancer. They just removed 10 mass out of my body, 7 out of my chest, 2 out of my diaphragm, and 1 out of the upper right lobe of my lung.
When did you become aware you had an illness? When did the illness begin? Do you remember?
Well, I went from COVID cancer, but I just had surgery May 7th of 25.
You said it happened during COVID?
Yes.
So in 2020? Again?
December 13th, 2020.
Okay.
And Harris is my, not only is he my caregiver, he's my power of attorney. He have all the final rights and know my wishes once God decides it's my time. But I'm a single mom and clearly don't have any other person in my life significant otherwise. Not really able to work. And a lot of times can't even get up and cook and take care of myself. So he is my main source. He is, and I'm asking for mercy of the court.
So basically for you, a day in your life, you deal with the treatment of cancer, right?
Treatment, pain, sickness. I could be well right now and a little bit later, balled up in the bed. So
right. So you can be balled up in the bed in excruciating pain.
Yes.
And agony, right?
Yes.
And while you're in this pain, what does Paris do?
Well, when he's home from work, he's the person that prepares the meals. He will bathe me. He will even change me or get me to the bathroom if I need it. He's good with that. He's real good. But he'll send food to the door through Uber Eats when he can't. If he's at work, he makes sure some food is coming to that door for me. Food, water, anything that I need. He's the person. He's my carrier, 100%.
So here's the last question, and I'll stop. I'll pass you the judge, and the prosecutor's gonna have some questions for you.
Okay.
But at the end of the day, we're familiar with his criminal history, right?
Mm-hmm.
We're familiar with the current offenses, right?
Correct.
But at the end of the day, you need him for survival, don't you?
Yes, I do.
And with that being said, are you asking for the court not necessarily to look at him, but let's look to you as someone who's needed, right?
Yes,
And are you begging again the court for its mercy
yes, I am.
by allowing him to have probation in spite of some of the things that he's done?
Correct. That's correct.
Thank you for your time.
Thank you.
Do you know why it took him 9 years to resolve that case in DeKalb County, Georgia? That's where you live, right?
That's correct. I have no clue how why that took so long.
I mean,
I don't even remember if I can remember it.
if he's the one that's responsible, helping you out, like we were talking about, you would think he'd take care of this a lot quicker than that, right?
I imagine.
I was just wondering. Thank you, man.
Anything else?
No, yeah, not from her.
A couple of issues I want to address on this. Number one, I heard what your mother has said, and yet with her illness, yet you're supposed to be taken care of. You committed after she was diagnosed and you knew she was sick. You committed, let's see, 4 different crimes and were convicted of 4 different crimes. And yet you knew she was seriously ill. And we're talking about in DeKalb County, Harris County, San Mateo County. So this is across the country, in Georgia, California, and in Texas. Also, you have 9 siblings, don't you? 9 brothers and sisters.
3 of them, or 2 of them. Huh?
9 brothers and sisters.
Yes, sir.
That's what the probation officer wrote because you told her that.
Yes, sir.
Is that right?
Yes, sir.
Where the heck are they? You've got 9 siblings. Aren't they supposed to be doing their part to help this lady? Or have you been abandoned by all 8 of your children?
They're not mine. They're from his dad.
No, that's not what this says. Reported to have 9 siblings shared between his mother and father.
I got 2 of her, the rest of with my dad.
This says 9 siblings shared between his mother and father. That's what the probation officer wrote. I know what that means. It's English. You have 9 brothers and sisters by her and a father.
That's correct.
Well, where are they? Why aren't they helping? The only person who's helping is the person who has committed. How many crimes did we talk about?
You said 13, sir.
Yeah, 13. But the criminal, the consistent criminal, is the only one of the 9 who is able to take care of you, but yet he keeps committing crimes while you are seriously ill. What kind of responsibility is that? Pathetic. Well, you can't lever your mother's illness as a method of keeping you from being held responsible for committing 13 crimes and another one here before this court. I mean, how can it's like I'll keep committing crimes and I'll use my mother's illness as a get out of jail free card?
No, sir.
No, that's what's being said here. You have 9 siblings. They need to be doing their part naturally, decently, Christianity-like way. It's a moral thing to do. Where are they? Or have they all abandoned you, ma'am?
2 of them have not.
2 haven't. Well, then they're going to have to take care of you because he's going to prison.
So,
And he's got to be held accountable. And with his rich criminal history, his lawyer has somehow fashioned a remarkable limit of his exposure for criminality. Because after all of these convictions and committing now 2 more convictions, crimes, which are similar in nature of dishonesty. These one of these is a 20-year possible sentence. The other is 10. He was looking at 30 years in prison. And these are the kinds of cases with a rich criminal history like you have that get stacked on top of each other. But he has fashioned a deal of a cap of 4 years in prison, which is pretty good arrangement. Is there any restitution here?
So, okay, I'm kind of looking, trying to find it on my file, but regardless, so right now we're looking at either 90 days or residential
No, I think,
treatment?
you know, Joaquin, every time we do a TRAS on someone and we deviate from what the results say, we really pay for it. Because they end up either picking up a new case or, you know, something even worse happens. I think probably the best thing would be to follow the TRAS and it's recommending treatment, which is probably a
Okay,
good
so
idea.
at this point, I mean, if I'm not mistaken, to get into residential treatment, he would have to stay in jail 6 to 8 weeks at least, and then get a bed.
Oh, no. You're kidding. Why?
I would assume.
Just because we did it while he was on the outside?
Probably, and at that point, it looked like she was working. They were looking at his post-social factors. I can see if they could do an addendum and see if he qualifies for like SATs or something.
Yeah.
What do you?
Do you think we can, how long would it take?
Maybe like a week.
Joaquin, so what the TRAS recommended was community residential, meaning that he would do it on the outside. I don't have
Okay.
much faith that he would get that done on the outside, number one. Number two, it would be extremely expensive because he would have to essentially pay for his own inpatient rehab facility on the outside, which, as you know, can run tens to 20 to perhaps even $30,000, depending on where you go to. If you go to these, you know.
Okay. Well, I mean, at this point, yeah, I think that's moot, Judge, because I'm pretty sure he's going to lose his job. I'm going to have to figure out a way. I'm going to go see him in jail tomorrow and talk to him about his options, and which seem to be very limited this time. But
Do you want to roll till tomorrow that we can come here so you don't have to go to the jail?
sure, we can do that, Judge.
Okay, we'll do that.
Okay.
Okay.
Well, then I'll see you tomorrow.
Okay, thanks, bud.
Thank you.
Can you try to expedite and see? Maybe hopefully we can get it done as quick as possible. Okay, thanks. Okay, Joaquin. Hi.
Good morning, Judge. I was approaching off docket about a defendant. Can I get you the question number?
Sure. Give me 1 second. Let me get there. Okay, what is it?
It's 259-2855.
Oh. Give me 1 second. Let me take it. Oy.
So
Oy.
I'm the felony prosecutor on this new DB case upstairs, but I was informed.
You're the felony prosecutor?
Yes, Judge. I was
Wow.
informed by my judge in court 487 that I needed to ask court 5 for permission about the sectional records because the basis of the VPO 212 is based off of the fact that he's being monitored in court 5.
Okay.
So I just wanted to check in and see if we could get those sections.
Let me talk let's do this. He's in jail now.
That's correct. He just did the mow-up upstairs in 487.
Can I put him on docket for tomorrow?
I think he is actually ready.
Great, because we need to also address, if he picked up a felony BPO, we need to also address conditions here, because he's got a BPO and an assault
Yes,
here.
Judge.
So let's do this. Can we talk tomorrow?
Definitely.
So can I
guess
reach
by
out to my
tomorrow.
staff, because I don't know how that puts, what kind of position that puts me in, you know?
Sure, definitely. And I do think that we have a motion. I filed it, at least at the felony court, but I was supposed to just kind of check in down here because technically he's being monitored in court 5.
Yeah, yeah, okay,
Okay, perfect.
Yeah.
I can come back. Thank you.
thanks. Is it for, because guys are having a hearing on the MOAP or? what
Yes,
do you-
Judge, I did file a motion for an 11C and felony, and so we were hoping to have those records instead of having to bring my complaining witness to testify as to the violations.
Got it. Okay. Mr. D.
Yes, sir, Your Honor.
Okay.
Thank you, sir. Your Honor, I am here on Mr. Chauncey Joseph. Back in April of 2025, fine was based on deferred adjudication probation for unlawful carrying of weapons. Subsequent to that, I've received notification from the probation officer that client violated with some technical violations, inclusive of failure to do his community service, report, tested positive for marijuana on one occasion, failing to attend the education program, thinking for a change,
Yeah, we had quite a number of issues with him while he was on bond too.
failure to report, and get verification of school enrollment.
What's reasonable, you know? It's his fourth case in a year.
I think he just picked up assault family arrest warrant.
Shut the front door. What?
Well, I checked with the chief judge and we looked over that and the chief couldn't find anything
Where did you
in
see
state or
that?
out of state relative to
I
that.
tried to run, I didn't see it in Harris County. I tried to run it through NCIC to see. I didn't see anything pop up.
Where are you seeing this?
The probation officer told me. We obtained a law violation for assault by family member on 116.
Let's do this. Can we roll it to tomorrow? Will you look into it to see?
Wait a minute. I'm sorry, Judge. I do see an arrest picture,
Okay.
but I don't see a charge.
Okay.
An arrest
I see a
picture.
mugshot in 160. Maybe it's out of county and there just takes a while to update. Like, that's another possibility, Judge. And it could be, let me see if there's any booking patterns.
Maybe. I don't want to do anything until we know for sure. So maybe we could set it for a couple days to give them time to look. Yeah, but whatever, you know,
Thursday. Okay. Fair enough, fair.
yeah, whatever you want, Mr. Dean.
Thursday.
Issued. So yeah, I don't see one, Judge, but yeah, maybe it could even be out of county and it's just taking a while.
Take, I'm Brad, so take your time. Maybe an investigator can see if something, you know, set up a couple days and then we'll
Yeah,
come
but
back.
I do see a mugshot in 160, so I don't know if that was, he did have a warrant out here. He got picked up as part of that, but.
Okay. You should know something about Thursday.
Yeah.
Okay.
Fair enough. Good.
Yeah.
Okay. Thank you. Thanks so much. There's a talk day when that Thursday. Yes, sir. Thank you so much.
You want to finish the list?
All right, John.
Moses Walter. You can come up there, sir. Judge Taco 22, a step 4 arraignment failed to appear and has a felony of the warrant.
What page was that?
Taco 26, I want to give it a you know, this.
5001.
Below that one, Martinez, it's a petition for non-disclosure.
I was gonna say 1,000, I'm sorry, 14,129 days old. Jeez. Hey, guys, on the non-disclosure, you guys,
Sorry, I meant to.
it's okay. It's on Martinez. What say you? Who's next?
Page 26, Oda. Federal arraignment failed to appear.
2501.
Top of page 37, Williams. Federal arraignment failed to appear.
2501.
Okay, how's that? What do you expect?
That's fine. It's fine. Victoria. It's fine.
Yes, okay.
Okay. Okay.
Oh, please sign it over, it's just like, so I'll just print it out. That's all, we're free to go.
Thank you.
You're welcome. Yeah. Also, there's a petition for non-disclosure.
Yes.
Defendants and the judge were trying to.
Judge, did you want to sign this continuance from last week?
Sure.
Yeah. And she said they haven't accepted charges yet, but they have.
Okay. So we're waiting for them to accept. I wonder if we're gonna get a 2B or what? Yeah, okay.
Let's show you that side.
Nothing first. On Victor Gonzalez. The Marvin Alvarez, case are connected. We're here for appearance next, first setting.
Oh, yeah. Okay, coming up, guys. All right, so Ms. Alvarez, you're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. And Mr. Gonzalez, you're charged with theft. You are facing up to a year in jail as well. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Dealer's choice.
November 26th, they're the same thing, Rob. So,
Oh, yeah, okay, got it.
November 26th, 2025, officers spoke to complaining witness who advised that she was in a physical altercation with defendant one and defendant two outside of her apartment at 4201 Fairmont Parkway in Harrisburg, Texas. Complainant advised she received phone calls from defendant Alvarez, and she then came outside where she was struck in the face multiple times by defendant Gonzalez and defendant Alvarez, and then fell to the ground and hit her head on a metal post near her apartment door. Officer observed injury to the head and blood, and that defendant Gonzalez took her phone and keychain before leaving the scene.
Okay. Is there any kind of relation whatsoever that you know about, perhaps?
Not that I know about, Your Honor. The DIM said that there was a argument over, I think it was like a T-shirt or something like that. But
Over a T-shirt. I am finding probable cause on.
Sorry,
It's okay.
But does it make reference to the minor that was I just didn't know if there was any more that judge needs to know in terms of us that might put it up for.
Judge, I was pretty direct with the agreements here. Complainant stated that when she walked outside, she saw defendant one, defendant one's sister, hereafter referred to as defendant two, and both of the defendant's fathers, hereafter referred to as defendant three. Complainant stated defendant one told her to run it. And this is, I know this is in medias res, but, defendant one told her to quote, run it, and began to strike the complainant multiple times with closed fist. To the complainant, she heard defendant three tell defendant number two to jump in, and that's when defendant two began to strike the complainant multiple times, along with defendant number one. Complainant added that in the course of defendant number one and defendant two's jumping on her, she fell to the ground and hit her head on a metal post near the apartment door. Complainant stated that after the altercation, she observed defendant three grab her phone and keychain prior to defendants fleeing the scene. It should be noted that the appearance attempted to get to defendants number one and two for their account. The incident had told with both defendants refused to speak to the law enforcement officers. Officers would be contacting number three via the phone, an address and negative results. As far as where you see that.
Joe, are you saying that there's a justification or something?
I believe you haven't identified them with defendant three.
We didn't have anything charged on the defendant three, so I think one was probably acknowledged, which is why there's three defendants, from what I can see here. What I can say is, Your Honor, the complainant from what we have is a 16-year-old acquaintance. It doesn't really say what other relations there are. I'm trying to look at. I have to say that she. I mean, I'm just trying to see.
Well, guys, I am going to find that there's probable cause to go forward with your case. As a condition of your bond, you're not to go within 200 feet of where this complaining witness lives, works, reads at all. You are not to have contact with this person whatsoever. You're not to be in possession of any weapons. I'm telling you now, if I find that you're a danger to my community, I only have one place for you. Do you understand? This is not a revolving door. And if I have to put you in jail, you will not get another PR bond. That means no new cases. Don't violate these conditions. I don't care what the cause is. Do you understand? You both have a lawyer. It is your responsibility to talk with him, and he can advise you on how going forward with all issues related to these cases. That's it. So what we're going to do now is I'm going to have you both sign a reset. I'll have you both take a seat while we get your bond conditions. Once you sign them at that point, you'll be free to go. Okay. So will you do me a favor also? Will you reach out to the complaining witness to let them know the condition that they're not to go within 200 feet so that they know if something should happen to notify, and then we'll take appropriate action.
Yes, sir.
Okay. All right. Please.
This way.
So no contact, no weapons, and no going within 200 feet, please.
Sir.
I have been through. I'm signing it just a minute. Council House Mark 17 Freedom Amendment. We're gonna be waiting, so this is.
Then the night needs to be good.
So problem.
Hey, you could put somewhere else. What the heck, man? Who dropped the ball on that?
Maybe I'm just going.
I mean, better not happen
All
again.
right, I got something to turn it off there, like, oh, happen, yes, I'm forgettable.
No. So reach out to whoever you talk to and say, no,
Yeah.
it's not gonna happen.
That's all this one, that's a sign.
No. We got a family and it's. No.
All right, go ahead and pass it. Okay, what was the last one? Yes.
He said the whole week.
Yeah.
Did you sign motion withdrawal? Brad Starter, I think we have, I think Will got.
Yeah. Did you get in there?
Yeah.
Okay. Hey, are we done with the list? Is that it? Got it.
You signed the petition for non-disclosure?
Yeah.
Can we get the defendant?
Yeah, okay.
Whenever you're ready, you scared it.
But that's it, right?
Michael Martinez?
Whatever happened.
Reset.
No, but they-
No.
I put the contingencies.
All right, we are done.
Difficulties. And instead of being the good son, not only to help her, but to make her proud, you continue to make the same kind of mistakes you've made. Or going on, well, since 2009. Today is 2009. 2008, sorry. 16 years? 17 years? Going on 18 years of criminality. And your mother is ill, needs you. So quite naturally, you continue to commit crimes in 3 different states. Okay. I don't feel sorry for you. I feel sorry for us. And yeah, you need to work on a whole lot, not only your own choices, but you need to quit putting yourself first. It was the great book Gail Sayers wrote, I am third. The supreme being is first, others are second, I come in third. That's why he's great. Yeah, it's a great message. You need to read that book because you keep putting yourself first when others should be placed ahead of them. You should be doing better work for others. The decent time, taking care of family needs. Anything else to add? Anything else you would like to add, sir?
Judge, if prison is going to be in, Judge, I would ask that on 4-year cap that you do 2 without having any definitiveness to his mother's condition. At least I think that would at least give him a chance to get out and to still be with her in her final days. And
okay, I'm sorry. Go ahead.
That's why I was asking for the. I was asking for that number.
I can't help but say that's not the way sentences and the justice system and the laws are supposed to work. Essentially, it's the circumstances of the offense and criminal history. He has dealt with his mother's condition for several years, and yet that has not deterred him. I'm worried about the community at large being subject to more criminality. His mother's illness and her need of him to help her. He has elected to continue to commit crimes of dishonesty, among other things, than do the right thing morally and decently. And the community is best served overall for everyone. Even though your mother needs your help, you should have been helping her when you were committing these crimes, when you knew she needed help. Shame on you. If nothing further by any party, I'm going to find you have pleaded guilty in each of these two cases, sir, in 25 CR 381 and 382, illegal possession and use of credit or debit card abuse, and a second degree felony, and the third degree felony of forgery of financial instrument. You have pleaded guilty in each of these felonies voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There is sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in each of these cases to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt in each of these cases. I am following these agreements. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years. These two sentences shall run concurrently. And I hope that your mother is able to get the help that she needs from other members of the family, the 8 other siblings, because you have failed her responsibly. You have failed by failing to follow the rules of law and by continuing to victimize other people. Shame on you. And I wish the very best for her. I know reared you better than you have acted over these 13 convictions for 20 some odd years. Anything else to add? That is all we are in recess on this case. Thank you. Here's this. Thank you, Judge. Here's us. I see Ronnie Linder has been reset. Yesenia Alvarez is reset. Clayton Eason reset. Lillian Ho reset. Michael Jenkins reset. Samuel